Test 1 2, test 1 2.
Okay, good morning. This is the regular weekly open meeting of the New Mexico Public Regulation Commission. Today is Friday, November 18th, 2022, 10 a.m. I'm Cynthia Hall, I'm the chair of the commission, and we will commence our meeting now. So first we'll have the call to order and roll call. Can I get someone to call the roll, please?
Apologize, I'm navigating
The camera?
Okay.
the setup of this room. The electricity's over on that wall.
Oh, I see. Thank you, Michael, General Counsel,
Turn on your
Michael
mic.
Smith.
There you go. Hot mic there.
Great, thanks.
Commissioner Cushman. Here. Commissioner Byrd.
I'm a present. Commissioner Maestas,
I'm here.
Commissioner Vicente Aguilar. And Commissioner Hall.
Here. Thank-
Appears we have a quorum. This is very different doing it like this rather than looking at names on a list.
It really is, isn't it? Thank you, Mike. Okay, and now I have the Pledge of Allegiance and the state pledge. Let's see. How about Mark Fenton? Yes.
It's a good thing you wore that sport coat. But the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Salute the flag of the state of New Mexico and the Zia symbol, perfect friendship among united cultures.
Thank you, Mike, Mark. Yeah. Oh, I see. Okay. Okay, next we have consideration and approval of the agenda. Does anybody have any changes or additions or deletions to the agenda?
We had a recommended change.
Yes, case, let's see. It was 18-00214 UT, in the matter of an order to show cause as to why Rosa Joint Ventures LLC should not be found in violation of the Public Utility Act and commission rules. I know he made some mention in an email, but that it may be either tabled or we could treat it as a discussion item. I'm not seeing Russell present. Is he?
Yes, Madam Chair, I'm here.
Okay, Russell, what do you prefer that we do? What's your recommendation? Do you think would it be possible for you to present it to us as a discussion item? Or do you feel we should table it? And why?
Madam Chair, I could discuss the situation a bit. I might not be able to answer every question the commission has at this point, although that might be just be a function of the filings being somewhat deficient. So I think it'll be more. We might need. I mean, actually, we might need to do a bench request in the meantime before November 30th. Plus, the motion at issue hasn't even been filed in the record. It's only been sent to me and other parties to the case. So it might be best to wait. But if the commission wants an update and a brief discussion today, that's something we could do. It's just it might be limited. And if you have questions for me, I might be able to answer some of them and not all of them. But of course, I could follow up on those. So it might be a way to make some progress and move forward.
Okay. Well, I propose that we keep it as a discussion item. When we get to that point on the agenda, then Russell can give us a brief update. So
Okay.
that I would like to amend the agenda to simply designate that case as a discussion only item. Nobody
Madam
else?
Chair,
Yes.
this is Michael Smith. I had one request, which is we have case 21. Sorry, I'm scrolling down. 22-00270 UT as item number 10.
Right.
I'd request that we actually place that between items 7 and 8 in the
Okay.
same section, which is
That makes sense.
Roman numeral 8B, and it would be between the 7 and 8.
Sure. Okay. Any other changes to the agenda proposed by anybody? Hearing nothing, I need a motion.
Madam Chair, I move to approve the agenda as amended.
Thank you. Do I have a second? Hey, I got a motion and a second. Can we take a vote, please, Mike?
Commissioner Fishman.
Aye.
Commissioner Byrd. Aye. Commissioner Hall.
Aye.
Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
The agenda is approved as modified by a vote of 5-0.
Thank you, Mike. All right, next we have introduction of special guests. Does anybody have any special guests to introduce today? Hearing none, I guess we'll move on. Public comment. Has anyone signed up for public comment?
Madam Chair, I did have one individual express an interest in public comment. That person indicated they would be in person at today's meeting. The person's name is Grady Bailey. So if he is present in the hearing room, he has signed up for public comment today.
Greg E. Bailey is Grady Bailey. I don't see anyone other than our employees. Well, we could check in the, we'll check in the adjoining room just to see if someone is in there who is Mr. Bailey, Ms. Bailey. Okay, apparently there's no Grady Bailey in our adjoining room, so I guess we'll move on. The next item is consideration and approval of prior meeting minutes, and this would be the minutes of October 26, 2022. 2022 open meeting. Does anyone have any additions or changes or corrections to the minutes? Hearing none. We need a motion to approve the minutes.
So moved.
Do I have a second? Okay, I got a motion and a second. Can you take the roll, please?
Commissioner Vicente Aguilar. Aye. Commissioner Maestas.
Aye.
Commissioner Hall.
Aye.
Commissioner Fishman.
Aye.
Commissioner Byrd.
Aye.
Okay.
The vote is rather the excuse me, the minutes of October 26, 2022 is approved by a vote of 5-0 with some humor involved. Courtesy of Commissioner Byrd.
Okay, we'll move on. Thank you. To consent action items. Does anybody have anything to say about the consent action agenda? Does anybody want to move any cases or anything like that to regular action item? Hearing nothing, I need a motion. So moved. Okay, and second?
Second.
Okay, we have a motion and a second. Can we have a roll on the consent action items?
Commissioner.
I think Michael
Oh,
needs to read the captions.
Oh, of course.
Oh, yes.
I apologize.
Excuse me. The consent action items are transportation matters 22-00264 TRM in the matter of the application of Access Medical Transportation LLC for a certificate to provide non-emergency medical transport service. That's a potential order regarding the application. Utility matters are case 19-00106 UT in the matter of applications for the 2020 broadband program support for the State Rural Universal Service Fund as per 17.11.10.31 NMAC. That's a potential order regarding Windstream's request for initial and midpoint disbursements of award for Hobbs project. Potential order regarding CenturyLink's request for midpoint disbursements for Deming Exchange. X 92.5 RL11 project, Hatch Exchange, X 23.8 Highway 140 project, and Hatch Exchange X 25 Highway 140 project. Next is case 21-00215 in the matter of Public Service Company of New Mexico's request for approval of new resources under 17.9.551 NMAC to replace 114 megawatts of leased Palo Verde nuclear generating station capacity. That's a proposed final order on remaining issues. Then case 22-00276 UT in the matter of the application of Public Service Company of New Mexico for approval of the City of Rio Rancho 2022 underground project rider pursuant to advice notice number 593. That's a proposed initial order and order on request for variance. Next is case 22-00188 UT in the matter of the application for a reliability determination for the Mora Line Transmission Project, New Mexico Renewable Energy Transmission Authority applicant. That's a potential final order on the application. And I'm sorry, no, that is the end of the consent action items. I will take the roll. Commissioner Hall.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Fishman. Commissioner Byrd.
Aye.
And Commissioner Maestas.
Aye.
The consent action items are approved by a vote of 5-0.
Thank you, Michael. Okay, now we'll move on to regular action items. And we actually have a transportation matter. It's number 22-00284-TR-EN. In the matter of the investigation of Enchantment Towing LLC, Erica Stefans will be presenting a potential order to show cause and to cease and desist. So Erica, if you're on Zoom, I
Morning. Yeah, good morning.
see.
Good morning, Madam Chair. Good morning, Commissioners.
Good morning.
So again, this is case number 22-00284 TREN in the matter of the investigation of Enchantment Towing LLC. And this matter comes before the Commission upon staff's petition for order to show cause and to cease and desist and recommendation for referral to the Attorney General. For some background, this matter was initiated by the Transportation Division staff upon receiving a self-reported notice on July 20th of 2022, where Enchantment self-reported an accident that caused damage to a vehicle that was in transit aboard Enchantment's towing equipment. Investigation of the circumstances surrounding the accident and the tow in question, staff's investigation, in addition to alleging violations surrounding the damage to the towed vehicle, also alleges other various violations of the Motor Carrier Act and the Motor Carrier General provisions. Specifically, the investigation alleged violations include improperly securing the towed vehicle to the towing equipment, violating the duty of safekeeping, not obtaining proper authorization from a property owner when a towing service is performed on private property, towing a vehicle from property that does not have visible signs to inform the public that the vehicle may be towed, and failing to provide proper notice to the owner or lien holder. And the investigation also alleges violations of the Unfair Practices Act. In staff's petition, they requested that Enchantment be sent in order to cease and desist any unauthorized motor carrier operations. Then Enchantment be sent in order to show cause, explaining why fines should not be imposed, and requesting that the Commission refer the case to the Attorney General's office to investigate possible violations of the Unfair Practices Act. The proposed order considers staff's petition, but it makes some jurisdictional clarifications and some additional orders. The proposed order sets out 5 requirements. First, it requires Enchantment to cease and desist the alleged business practices identified by the Transportation Division, which allegedly violate the Motor Carrier Act and the Motor Carrier General provisions. Second, it requires Enchantment to file a response to show cause as to why it should not be fined for violations of the Motor Carrier Act. And that response would be due by December 9th. Third, it requires staff and Enchantment to attempt to reach a settlement agreement regarding the claims in the investigation and to file a status report regarding that settlement agreement. And that would be due no later than December 16th. If a settlement is reached, then that agreement shall be presented to the Commission for approval and no further proceedings would be necessary. Fourth, in the event that the parties can't reach a settlement, the order appoints a hearing officer to be named after December 16th, and that hearing examiner shall hold a public hearing and make a recommendation to the Commission as to whether Enchantment's operations endangered public health and safety and what proposed fines and penalties should be imposed for violations of the Motor Carrier Act. And lastly, a copy of this order would be sent to the Attorney General's office to investigate any claims under the Unfair Practices Act, under which the commission lacks any jurisdiction to make those orders. So this recommendation, the reason that OGC is recommending this proposed order is that it would require enchantment to cease and desist any action that violates commission rules and regulations. It allows enchantment an opportunity to respond to the allegations and to argue against the fines. It would allow enchantment and staff an opportunity to attempt to work this out via settlement. And if a settlement can't be reached, it moves the case forward by assigning a hearing officer to then make its recommendation regarding the operations and whether any fine should be imposed. And then again, a copy would be sent to the Attorney General's office to investigate under the Unfair Practices Act and handle the case as that office seems fit. As to timeline, which becomes more and more relevant as we approach the new year, given the commission's current schedule, unless the parties reach a speedy settlement, this matter is likely to extend beyond the new year and be in front of the new commission. And I'd be happy to answer any questions the commission has about the proposed order.
Thank you. Thank you very much. Thank you very much, Erica. I really appreciate that thorough explanation. Do any commissioners have any questions of Ms. Stephens?
I will move the order.
I have a question.
Oh, we have questions?
No, you can do the motion in order. Yeah, motion. Yeah.
For
Good.
the
Okay.
purposes of discussion, I'll second that.
Great. Thank you. Great. Any discussion, commissioners? Okay, well, I just have one question, Erica. I was just wondering what are the alleged facts for violation of the Unfair Practices Act?
So the rules and regulations require that the towing service acquire authorization from a property owner or their agent prior to towing from a private property. And it's a bit complicated, but to keep it simple and straightforward, the investigation alleges that Enchantment is having their own administrative assistant sign the authorization forms instead of the property owner or agent.
Did staff have that reviewed by an attorney, by a staff attorney, to see if that's adequate allegation?
Sure. I don't
mean,
think.
Did they, I say, I'm asking, did they do that? Do you know?
Don't know.
It might be worthwhile to have them vet that. I'm not sure that rises to the level of a unfair trade practice.
Madam Chair,
Yes,
sorry to interject. The petition from staff did ask, since the Unfair Practices Act would largely be covered by the state attorney general, Attorney Stephens and myself did reach out to the Attorney General's office, asking them for a contact name of who would be the proper person to review any unfair practices, and they did provide us with a name which will be referred to in the order. So to the extent that staff asked us to delegate that to the Attorney General, this order that Attorney Stephens prepared does handle that.
is that in the ordering paragraph somewhere here? I'm not sure I'm following you. And you say it's handled in this order that.
I believe the order indicates that we technically would not have jurisdiction over a claim of that nature, and the the person that the Attorney General asked us to forward that to will be included in the certificate of service for this order.
The person on staff who
Not,
asked,
not on our staff, the person at the state attorney general's office, who is responsible for reviewing orders that are referred to them.
okay,
So that portion will be delegated to the state attorney general's office.
oh, I see what you're saying here.
Yeah.
Shall mail a copy of this order to the advocacy. Okay, so that's the nexus. And so they'll review whether or not it rises to the law. Okay, fine.
Exactly. They will be the ones in charge of reviewing that.
All right, fine. Okay, so I have no other questions. Commissioners, anybody else have any discussions? No? Okay, so I need a motion to move this
We
order.
already have a motion.
Oh, we do. We have a motion and a second. Okay, so Mike, can you take the roll?
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Maestas.
Aye.
The order is approved by a vote of 5-0.
Okay, we will move on to the next matter. And that's, now we're getting into utility matters. This is case number 21-00158 UT. In the matter of an investigation into the viability of Public Service Company of New Mexico's Sky Blue Voluntary Renewable Energy Program and whether it should be replaced or discontinued. Russell Fisk will present a potential order regarding the recommended decision and exceptions. So Russell, could you please proceed?
Yes, good morning, Madam Chair, Commissioners. Last week during executive closed session, the hearing examiner, Anthony Medeiros, presented his recommended decision to the commission. And this week, I'll just be going through the exceptions that were filed by New Energy Economy, PNM's response to those exceptions, and how the order that I proposed would address those exceptions. So you're following along. I sent a revised memo and order yesterday to correct one portion of the order, which is at paragraph 29, and a portion, the corresponding portion of the memo, each just one paragraph. So you should be looking at, if you want to follow along, the memo from yesterday, November 17th. All right. So as you will recall, this matter concerns the voluntary participation program by PNM called the Sky Blue program, which is a program that was instituted to allow ratepayers to choose to pay a premium on their utility bills to support renewable energy. And there was a previous docket number 20-00124 UT, which figures into this docket to some extent, in which the commission considered whether to terminate the Sky Blue program. And the commission decided to, in that case, reject the recommendation of the hearing examiner in that matter to begin to require PNM to file an application to terminate the program, and instead decided to undertake a brand new, fresh investigation based on a new record to determine whether or not the program should actually be terminated. And that is this proceeding, this docket. It began as an investigation into the viability of the Sky Blue program going forward. And as you will recall, the gist of the RD was that there would be a 3-year transition period starting from the date of this, of the commission's entry of a final order in this matter, if such a order did indeed adopt the RD through November 1st, 2025 for review of the program's performance, particularly because in recent months, possibly recent years, I think it's recent months. So the program has turned a corner in terms of instead of operating at a monthly loss, has been generating more income within the program, revenue within the program than it spends. Finally, revenues exceed costs. So it's beginning to draw down a very substantial regulatory asset that would otherwise be for which non-subscribing ratepayers, including, in other words, people who are not participating in the program would become liable for in rates. So during the transition period, as Anthony discussed last week, there's a chance, a good chance, that asset will be continued to draw down, and that asset is essentially a debt. It's a debt of the program. And there'll be more information about whether the program itself is worthy to go forward, to continue to go forward after the end of the transition period. So that's a brief recap of the recommended decision. So I'll just jump into my memo now. So there were a number of exceptions filed by New Energy Economy, or NEE. And first one, as you see from my memo, is somewhat of a grab bag of a number of exceptions really put together. As you notice, as I noted in the memo, and as a proposed order would note, an NEE has filed a set of exceptions that has 9 exceptions, but really 1 through 8 are all one set of exceptions, and then 9 is a separate exception. So this memo really deals with number 1. Then, and the proposed order does it the same way. Deals with number 1, and then the commission would say we agree with PNM that 2 through 8 are already subsumed within number 1, and then it goes on to 9. So really, there's be 2 that are discussed today: number 1 and number 9. So number 1, the exception number 1, is that NEE takes exception to the hearing examiner's, quote, striking from the record the documents attached to NEE's brief in chief and the references therein to the transcript and testimony admitted in docket number 20-00124 UT. NEE argues that this evidence was competent and relevant to the scope of the investigative inquiry ordered by the PRC. NEE further contends that this evidence was given the protection of administrative notice, and the commission's final order partially adopting recommended decision in that previous docket. NEE contends that the hearing examiner has mischaracterized NEE's actions as belated, disruptive, and ill-timed, and has taken an unwarranted adversarial position with regard to NEE's legitimate assertion that the Sky Blue program should be discontinued immediately. NEE goes on to argue that the PRC intended that this evidence be used to inform the issue, and that there were no legal impediments preventing the hearing examiner from admitting this evidence sua sponte in the interest of justice and administrative efficiency. And just to remind the commission, sua sponte means that the court, or in this case, the hearing examiner, could have decided to admit the evidence himself, even though NEE didn't actually move for administrative notice, and he simply attached the documents to its post-hearing brief. NEE saying, well, the hearing examiner could have, even without a motion, have done so on his own motion. NEE contends that the pre-filed testimony in this case by PNM's witness Alaric Babej and Commission utility staff witness John Reynolds did not contradict NEE's assertion that the Sky Blue program has been a burden on the ratepayers of New Mexico since its inception. NEE argues that allowing PNM an additional transition period should have required an in-depth analysis into whether the program currently met the objectives of the law. NEE contends that the hearing examiner chose to reject and ignore evidence. Sorry, I'm getting a lot of pop-up messages that would have specifically aided and informed this inquiry, and did so not because the evidence was in any way deficient, but because he was angry with the manner in which it was raised. And he argues that the approval of a transitional period will result in prolonging the life of a program that has been shown to be financially unhealthy, unnecessary, legally non-compliant, and harmful to the ratepayers of New Mexico. In its response, PNM addresses NE's exceptions 1 through 8 together, as I said, because all of them involve the hearing examiner's ruling, striking documents attached to NE's brief in chief that were outside the evidentiary record in this case. PNM argues that with regard to NE's exceptions 1 through 8, contrary to NE's unqualified claims, the purported evidence attached to NE's brief in chief was not granted the protection of administrative notice in the previous hearing examiner's recommended decision by the PRC in its final order in that case. On the contrary, PNM notes that the commission's final order in that previous docket expressly rejected the hearing examiner's recommendation that PNM be ordered to file an application to terminate the Sky Blue program. PNM argues that the commission's express rejection of this recommendation implies that the commission also rejected the recommendation that administrative notice be taken of evidence and findings in that matter. PNM states that the commission instead ordered an alternative independent investigation, and I'll skip the quote in the memo there. PNM further states that NEE stipulated, along with the 3 other parties to this matter, that's NM Area and New Mexico Affordable Reliable Energy Alliance, staff of the commission's utility division, and PNM, that the evidentiary record would contain only the pre-filed testimony of Mr. Babej and Mr. Reynolds in this matter. PNM notes that when stipulating to the evidentiary record, NEE reserved the right to make arguments in its brief that PNM had failed to meet its burden of proof with respect to the Sky Blue program, but NEE did not request that any portion of the evidentiary record include materials from a previous docket. PNM notes that the hearing examiner entertained only those arguments made by NEE in its post-hearing brief that were based on the stipulated record of evidence in this matter and did not consider the material from docket number 20-124 UT attached to the brief. And by the way, my use of the term post-hearing brief might be a bit misleading here because there was no hearing. There's a stipulated evidentiary record from the pre-filed testimony, but it was sort of a post. After the evidence was stipulated to, there was briefing after that. So there wasn't an actual hearing on that. The proposed order, those are PNM's responses. The proposed order that I propose, would have the commission reject this exception and would state the following findings and conclusions. That the commission agrees with PNM that the commission's express rejection of the hearing examiner's recommendation in docket 20-00124 UT to require PNM to file an application to terminate the program implied rejection of the recommendation to take administrative notice of the material that NEE attached to its post-hearing brief. The hearing examiner's recommendation in that docket regarding administrative notice was clearly tied to the recommendation to commence a termination proceeding, whereas the commission decided to start afresh with a new inquiry into the question of whether termination of the program is the best course of action. The commission further concurs with PNM that NEE stipulated to the evidentiary record, which did not include the material from docket number 20-00124 UT. NEE's reservation of rights concerning the arguments that NEE planned to make did not preserve any right that NEE may have had to introduce evidence that was not part of the stipulated record. Had NEE's reservation of rights included a reservation of right to introduce evidence that was not part of the stipulated record, it would have rendered NEE's stipulation meaningless. As for NEE's claim that the material from the previous docket is critically important for the commission's consideration of this matter, the commission disagrees. As noted above, including such material would be contrary to the commission's previous determination that this proceeding would be a fresh consideration of the Sky Blue program, independent of the record and findings in the previous docket. Moreover, the commission finds no reason to deviate from that original plan, as the stipulated record in this matter fully develops the relevant issues and includes more recent information. And then finally, the commission strongly rejects NEE's baseless claims that the hearing examiner took an adversarial position against NEE and that the hearing examiner refused to take administrative notice of the material from the previous docket because he was, quote, angry about the manner in which the issue was raised. The hearing examiner's procedural and evidentiary rulings in this matter were correct, both legally and factually. If anything, the hearing examiner was somewhat indulgent toward NEE when the hearing examiner decided to accept NEE's untimely post-hearing brief and to sift through the brief to address only those arguments that were properly based upon the stipulated record. In addition, his substantive recommendations regarding the Sky Blue program and his reasoning supporting such recommendations are sound and well taken. It is NEE's behavior in this proceeding that the commission finds troubling. NEE first stipulated to an evidentiary record and then, without consulting the other parties to the stipulation or moving for leave to introduce evidence outside of the stipulated record, attempted to add evidence simply by attaching it to NEE's post-hearing brief. NEE behaved as if it had not entered into the stipulation at all, or as if the stipulation were insignificant. NEE continues to do so in its exceptions. NEE's contention that its reservation of rights regarding arguments that it planned to make somehow preserved a right to introduce evidence outside of the stipulated record is completely without merit. There scarcely is clearer distinction in legal proceedings, whether civil, criminal, or administrative proceedings, than the distinction between evidence and argument. And the proposed order would state, as I noted already, that exceptions number 2 through 8 are subsumed essentially between within exception 1, as PNM argued. The proposed order would state that the commission's findings and reasoning above, in other words, with regard to exception number 1, apply to these exceptions as well, will be incorporated in that portion of the order by reference. And just as with number 1, the proposed order would have the commission reject NEE's exceptions 2 through 8 on the same bases. So moving on to exception 9, which is the last exception. NEE takes exception to the hearing examiner's finding that PNM has shown by a preponderance of record evidence that the company's proposed transitional plan for evaluation of the program, as informed and supplemented by staff witness John Reynolds' recommendations, in other words, PNM was willing to adopt those recommendations, is reasonable and should be implemented. NEE cites the hearing examiner's statement that he did not and would not recommend the continuation of the Sky Blue program during the transition period unless the program in its current form meets the objectives of the Renewable Energy Act and Rule 572, the commission's rule. NEE asks rhetorically how the hearing examiner could possibly conclude that the continuation of the Sky Blue program met these legal objectives without assessing the evidence elicited in the previous docket. NEE states that this was evidence that had persuaded hearing examiner Glick, who was the hearing examiner in that previous docket, that the program should be discontinued and prompted her to require PNM to apply for termination of the program within 30 days of the final order. NEE contends that the hearing examiner was well aware that his program did not currently meet the objectives required for continued operation and that permitting a limited transitional period would not change this fact. NEE cites the hearing examiner's reference to testimony that raised the issue of whether, given the state of its current operation, PNM would ever be able to fully recover the Sky Blue program costs. NEE objects to the hearing examiner's finding that it is also possible, for whatever combination of reasons attributable or unrelated to community solar, that Sky Blue's regulatory asset balance could begin to reverse course and begin increasing again. NEE states that the program has been running at a loss and costing non-subscribing ratepayers money since its inception in 2013. NEE argues that under those circumstances, waiting an additional 3 years to see if the program could turn itself around was not reasonable and does not comport with the law. NEE goes on to cite the recommended findings of the hearing examiner from the previous docket. I'm not going to go into detail on those for a reason I'll explain soon. NEE further contends that the testimony filed by Mr. Babej and Mr. Reynolds doesn't establish that non-participating PNM customers will not continue subsidizing the Sky Blue program, a program that has not been self-sustaining since its inception in 2013. And in its response, PNM contends that most of NEE's arguments focus on evidence from the previous docket, which is not before the commission in this docket. PNM argues that all the testimony admitted in this case supports a proposed transition period for evaluating whether the program should continue in its current form or should be modified or replaced. The proposed order would have the commission reject NEE's exception number 9, stating, as noted by P&M, NEE relies upon the material from the previous docket that is rightfully not part of this evidentiary record. NEE goes further in this exception, though, and implicitly argues that the hearing examiner should have made the same recommended findings and come to the same recommended conclusions that the hearing examiner in the previous docket did. NEE's reliance upon such recommended findings and recommended conclusions is misplaced. The hearing examiner correctly followed the instructions of the commission in that previous docket to take a fresh look at the program in this proceeding and correctly disregarded the recommendations of the hearing examiner in the previous docket, which the commission had rejected. NEE's contention that approving the transition period will result in additional losses that will be charged to ratepayers that have not subscribed to the program reflects a fundamental misunderstanding of the situation at hand. The vast majority of the costs at issue have already been incurred and have been approved by the Commission for Recovery and Rates. The regulatory assets currently, just as an aside, is approximately $2 million, to the extent that they are not recovered from voluntary subscribers to the program. NEE also mischaracterizes Mr. Babej's testimony concerning the current financial performance of the program. NEE states that Mr. Babej testified that the program's deficit has lately been reduced from $18,000 per month to $10,000 to $15,000 per month. Mr. Babej actually testified that his earlier testimony in docket number 20, in their previous docket, was that costs exceeded revenues by approximately $18,000 per month, but that the trend in recent, oops, I think this must be an error there. I'll correct that. Recent years or months, I think months, is that revenues, yes, that should be months. I will add that to the proposed order. Is that revenues now exceed costs by between approximately, revenues now exceed costs, let me make the emphasis clear, by between approximately $10,000 to $15,000 per month. So just to restate that. NEE, in its exception, states that Mr. Babej, P&M's testimony, had testified that the program's monthly deficit, in other words, it's the level of costs, degree to which costs exceed revenues, has been reduced from $18,000 per month to $10,000 to $15,000 per month. Whereas Mr. Babej actually testified that at the time of the previous docket, costs exceeded revenues. In other words, there was a monthly deficit of $18,000, but that the trend in recent months is that revenues exceed costs. In other words, it's turned from the red to the black on a monthly basis by between $10,000 to $15,000 per month. Going back to the language of the proposed order, if the current financial situation continues or even improves due to recent trends in non-residential customer participation identified in the record, then the transition period may provide a substantial decrease in the program's debt, relieving non-subscribing ratepayers of a substantial portion of this obligation. In any event, because the bulk of the costs have already been incurred, approving additional time for transitional period will not result in non-subscribing ratepayers being obligated to cover significant costs, which they would not otherwise be obligated to cover, which they, significant costs which they would not otherwise be obligated to cover, and may instead reduce the costs for which they are already obligated. NE's position also implies that it would be proper for the commission to rely upon the record of the program's lackluster performance to disapprove the program retroactively as of the date of the commission's approval of the program, or to disapprove the program as of the date of this order. NEE's argument that the recent change in Rule 572 is a justification for discontinuing the program further illustrates NEE's mistaken assumptions. The commission's decisions to approve the Sky Blue program and to allow for recovery of any program deficit and rates were made based upon the record, the law, and the commission's rules as they stood at the time that those decisions were made. Neither new information, new law, nor new rules should have a retroactive impact upon those decisions. And with that, I'll take any questions.
Thank you very much, Russell. That was very comprehensive. Commissioners, do you have any questions of Russell?
Madam Chair.
Yes, Commissioner Fishman.
Yeah, just two quick ones. Russell, in the Sky Blue program, in terms of depreciation of assets, are those depreciated on an annual basis as REA assets are? or on a straight line annual basis? And are those calculated into the rates on an annual basis? Is that how that works?
Commissioner Fishman, that's a good question.
Distinct, just to be clear, as distinct from something that's been rate-based, and the write-down only happens for rate-making purposes only when a rate case happens. This happens annually, as I understand it. Is that correct?
That's my understanding as well. But I'm not 100% clear on which portion, because there's obviously there's a 1.9, or as of a particular recent date, a $1.9 million regulatory asset to be recovered. So it's not, so not everything is recovered in rates on a monthly basis. So there is, like I said, there's a buildup of costs to be either reduced through surpluses, monthly surpluses in the program, or paid by other paid for it in rates. So some part of it is accumulated already. I'm sorry, Commissioner Fishman, go ahead.
Well, I was just gonna, the hearing examiner is in the room. I don't know if he doesn't want to answer any questions. Okay, I'm not going to push him into a hole there. So there is the distinction, though, that this is the annual depreciation rates in the REA cases annually. It gets adjusted. And if that's the case, is that part of the reason, in addition to corporate interest in this program, that we're now seeing favorable?
Yes.
Okay.
Yes, Commissioner Fishman, that's correct. I had only mentioned, you're correct, in the proposed order, I mentioned the recent trends in non-residential participation in the program, because that's a large part of why there's been a turnaround from being monthly in the red to monthly in the black, because these non-residential, these business customers contribute quite a bit. But there's also it's also mentioned as a reason for the change, and the more positive recent trend is the writing off of the depreciation.
Okay. Got it. Second question. I think I forgot now.
Take your time. Maybe it'll come back.
She's just, see, some people respect the senior moment. Others just have no respect at all. You're getting older too, buddy.
It'll happen to you too, eventually, maybe.
So that was the appreciation. It was having to do with administrative.
Madam Chair,
Notice.
Mr. Fishman, Commissioner Fishman, your mic is muted. Damn right.
Okay. In terms of administrative notice, I just want to boil the issue down to the nub here, which is the reason administrative notice is required is from the previous cases is that if you bring information or testimony up from a prior case, but the folks in the current case have not had any chance to look at it and respond, then we've got a due process issue where people have not had a chance to respond to all the arguments raised in the case. So it seems a pretty simple proposition that administrative notice would be required and very logical. You know, I would ask that all participants in our dockets respect due process and respect the idea that all parties should have an opportunity to respond to issues raised and arguments raised. And the arguments raised and the questions asked in a prior docket were raised in different circumstances, in different questions, in different parties participating. necessitate this rule. And Anthony did a great job of explaining that to me. And I really appreciate that, and I really understand it. So I do think that all the issues raised about due process, it's not complicated, it's not hard to understand. And I really respect all the parties in these cases, but again, let's follow the process. The rules are there for a good reason. Let's follow them. And with that, I'm done.
Thank you.
And Commissioner Fishman, I agree. And I just want to know in this case, what you said is true of every case. And in this case, there are two additional reasons that the administrative notice shouldn't be taken of those documents from the previous case. One is that the commission's decision in the previous case was to reject the hearing examiner's recommendation and to start afresh. I think afresh is even what the word that was used by the commission, not to consider that record, but to start again. So that's a special additional reason for, in this case, not to take administrative notice. And this other reason is that all of the parties, including NEE, stipulated to an evidentiary record that did not include those documents. So in addition to what you're saying, which applies to every case, there were two additional reasons not to do so in this case.
Other commissioners have a comment or question of
Madam
Russell?
Chair.
Yes, Commissioner Maestas.
I get really concerned whenever we make these abrupt policy changes. The previous docket recommended termination, and the commission asked for an independent investigation in a new docket, and that's what we're dealing with. New circumstances, new arguments, but I'm concerned that we went from recommending program termination to basically a 3-year extension, and the extension, based on the record as I understand it, is based on staff's speculation that by November 2025 we could perhaps have at least a 1-year experience of having some community solar projects in operation, and that would be the ideal time to gauge continued interest in Sky Blue relative to the community solar program. But if you look at the previous docket, it was the trends that triggered that particular docket. And it was a trend of costs far exceeding revenues. But in this docket and at this current time, trends are much more positive. But is there any guarantee that those trends will continue? And so what I'm getting at is, to me, there's no trigger between now and November of 2025 that would allow the commission to reevaluate the program. Because again, there's no guarantee that these trends will continue. And that's my only concern, Madam Chair, that I think that there should be a trigger before the end of the transition period. Obviously, PNM is going to evaluate the program, but the results aren't going to be made available until the end of the transition period. And I feel, given where we've come from, that this body should establish some kind of a trigger to bring it back for evaluation. Perhaps it could be 6 consecutive months of costs exceeding revenues. So I guess my question before we maybe discuss it as a commission, Russell, did you consider any kind of trigger that would cause a reevaluation of the program prior to the expiration of the transition period?
Commissioner Maestas, I have received from Christopher Hall some proposed language just a few minutes ago, which I will read. What you said, Commissioner Maestas, is absolutely correct, except for I just like to make one clarification, which I don't think will really make a difference when it comes to the trigger issue, which is that there will be reporting with regard to the the monthly performance of the financial performance, whether the surplus on a monthly basis continues or whether it becomes a deficit, and by how much. In P&M's annual reporting, that's a specific requirement of the RD. And it would be stated on a monthly basis, but it'd be reported to the commission on an annual basis. So the commission wouldn't have to wait until the end of the transition period, but it would be a year because it's part of the annual report. So there would be quite a long period in which the commission didn't have that information, and then it would receive the information broken down by month. But it would be a year, be whenever P&M files its annual report. So I can understand why
Russell,
the commission
if I may, but there's no trigger or performance metric based on this reporting that would require any specific action by the commission.
Correct. Correct. It would, yes, that's correct. It would require the commission, someone would have to notice and bring it before the commission's attention, say if the first annual report indicated that things had changed. There's no automatic trigger in the RD for that. And if you like, I can go ahead and read what Christopher has proposed.
Yeah, we've been working on this, but I thought I'd run it by you first. So
Wait, well, let me read. I'm reading it myself for the first time right now. So this should be added to the ordering paragraphs if the commission wished to do so. Additionally, a reevaluation of the program and whether it should be terminated will be triggered automatically if at any time during the transition period, program costs exceed revenues for 6 consecutive months, or for any 6 months in a 12-month period, or if the regulatory asset balance increases for 6 consecutive months, or for 6 months in any 12-month period. So these seem like reasonable triggers, although I think that, let me say that the second stat about where it describes as the regulatory asset increases, I don't know if that's completely redundant or not. Probably not, because it's not just okay. So, this is something that makes sense to me. The one thing it doesn't have is an actual procedure by which the trigger would happen. So I think there would have to be some language that would require staff to bring it to the attention of either P&M to file something, because staff will also only receive the information on an annual basis, or P&M would be required. The commission could require P&M to file some sort of notice with the commission, or an application to reevaluate the program if any of these things happen, because some of these things wouldn't be known to the staff or any portion of the commission until the annual report were filed. So we'd have to add something saying how the trigger would operate, which I think would have to be by P&M for it to be in a timely manner, because they would have the information before the staff would.
thanks, Russell. I thought that there was reporting on a monthly basis regarding the performance as well, in addition to an annual report.
Actually, no, it is the annual report would break it down by month, but the annual report will still be filed annually.
All right, thanks, Russell. So I guess that's my only issue is I feel like just letting this, go on for 3 years without any kind of trigger, given where we've come from, is maybe a bit too lax. We already have the reporting, so we're going to have the information, but as the order currently stands, there's no direction. What should staff do if it starts losing money? And what should the commission do?
Thank
Chair,
you.
just
Commissioner Maestas. Yes, Commissioner Fisher.
so listening to Russell, it sounds like a little bit of a wormhole to that we go down procedurally there. And I'm wondering, I think Commissioner Maestas raises a really good point.
Mhm.
I'm wondering if we could address it a little more simply, though, by just requiring staff at the point that report comes up to annually present to the commission those results, and then the commission can decide whether it requires further study, as opposed to trying to put in standards that people can argue about in the future. Does that make any sense, or does it not fill the bill?
It does.
Well,
It does, but I'd like to hear, I'm willing
Other
to
comments?
compromise on that, but I do feel that there should be some kind of process. If this thing starts going south again,
well, just to follow up on what Commissioner Fishman said, I think the difficulty you run into with having staff present annually is you could have a trend occur in the first 6 months, which wouldn't be reported on until the following 6 months. So, and that's kind of thwarts the objective of the ability to have transparency at the 6 months, after 2 quarters, I guess that's how I was wondering, how did you pick 6 months? But I guess it makes sense if you just look at 1 quarter's information. If you look at 2, then maybe it's a trend. So I don't know that it's so onerous to require the utility to just inform staff what the cost versus revenues are.
Well, and it may be that I misunderstood a little bit, is that if this 6 month thing happened, there would automatically be a restudy. And I guess what I'm aiming for a little bit is, instead of setting an automatic restudy, knowing there's limited resources, that we might want to provide the commission an opportunity to exercise its judgment about whether that's the right way to expend agency resources at that moment. There might be other priorities. And if you automatically kick a restudy, and then we're just potentially piling work on top of work when we don't want to. So that's my concern.
Well, thank you for that, Commissioner Fishman. Any other commissioners have any comments on this point?
well, Madam Chair, I guess I would just, maybe add that if that inflection point or that change happens from revenues exceeding cost to the opposite, that could trigger a notification from staff to commission based on the annual reports.
There you go.
And I think that's
Okay, based on annual reports.
instead of trying to define like a trend of losses, you might have a different idea. Commissioner Vicente Aguilar might have a different idea of what a troubling trend is in terms of costs exceeding revenues.
So my only concern there is I just don't want to trigger automatic work. I just like the commission to exercise its judgment on that.
Okay, thank you very much, both of you. To Commissioner Maestas' point, though, I guess just to make sure I understand what you wanted to see, I thought you wanted some sort of notification at a 6-month period.
No, it would
If
be
there was such a trend.
if there were 6 consecutive months of costs exceeding revenues, but again, that's very subjective. And
Well, I don't know why it would be subjective. It's either revenues are higher or costs are higher for 2 succeeding quarters. And if that were to occur, that could be the condition that would trigger notification from the utility, the staff, and the staff would inform us and we could decide then. It might never occur.
Yeah.
So it wouldn't have to be tied to an annual, the annual report could always describe it, but if it never happens, it never happens. So, if you just condition it on those, if you just, want to ask for, notification from the agency, from the utility.
well, right now there is a distinct staff role, right? But there's no specific instruction of staff based on the information in the annual report to bring to the commission. Like what should they do? And so that's my only concern is I think that there should be some kind of a trigger or a performance metric or a change in the trend, because that's what we're talking about here is our trends and they change.
Right.
This program has been, I'm not going to say volatile, but it's changed over the years.
Correct.
And personally, I don't think it's going to compete with community solar. So I see perhaps costs starting to exceed revenues again for lack of participation. But again, that's really speculative. And that's the danger of looking at a point in time situation, which is kind of what we're basing this on. We're basing it on the point in time trends and then kind of a speculative end of the transition period based on community solar implementation. And I think we should stay focused on the program and the trends and monitor it, for the next 3 years during this transition period instead of waiting until November of 2025.
I understand. And I think that's an objective.
Madam Chair, so here's some language I think would embody what Commissioner Maestas is asking for now. Staff shall review, this would be in the final order, staff shall review P&M's annual report. And if at any time during the transition period, program costs exceed revenues for 6 consecutive months or for any 6 months in a 12-month period, or if the regulatory asset balance increases for 6 consecutive months or for 6 months in any 12-month period, staff shall promptly file with the commission a petition to review the Sky Blue program.
Thank you, Russell. Well, I guess in my opinion, that gets us halfway there. But if they're only reviewing an annual report, and if the trend changed in the first 6 months of that year, we don't find out until 6 months later. So
that's true. So the commission could require more frequent reporting by P&M. It just sounded to me like Commissioner Maestas had changed, had decided that an annual basis based on the annual report might be acceptable. But it's true that might happen. The change in the trend might happen. Months and months before the annual report were filed.
So I would suggest we put language in that says P&M needs to report on a 6-month basis. Actually, yeah, that would work. Or 6-month basis, or every time you have 2 consecutive quarters of a different trend. That's really what we're looking at. 2 consecutive quarters of a trend in the opposite direction from what we have now.
I'd say the language that Russell just mentioned with your suggested change in the reporting frequency from 1 month to 6 months, I think would suffice, at least to me.
Can you repeat to me then what the terms would be?
Well, the reporting requirements would be every 6 months
From the
during the
utility?
transition period.
From the utility
Yes,
to staff, and then staff to the commission.
right. But the
Okay,
trigger,
we can figure out if there's a trend, but that doesn't really address it. If you really want to watch what happens after each, you would want to be looking actually whenever it occurs that you have 2 subsequent, that you have 2 consecutive months. So if they reported at 6 months, they might be catching only the latter quarter in that 6 months if the utility reported. So we don't have a trend, but we have an uptick in the second quarter. And then thereafter, the next reporting period is 6 months later. And the utility would then say, oh, in the first quarter of this reporting period, there was an uptick. We would have been a quarter late in perceiving that. 2 months.
but I'm not sure that this commission wants to really take a too granular of approach, because it could be that it breaks even. I mean,
That's true too.
is that
So
a
that's
reason
good
for us to even discuss it, or the next commission? So I like the language that Russell mentioned, with more specific staff direction coupled with the
Utility
reporting
reporting.
requirements to be on a 6-month basis
Yeah, I
instead
think
of a
that
year.
works. Now that we talked through it, I talked through it. I think through it. Yeah.
I was listening.
Okay.
Russell, how does that sound to you?
It sounds
Okay.
fine. Any of these options is fine with me. These are all within the policy choices that the commission can make. I just want to make sure I get the language right. So I'm going to type it and read it right now. P&M shall report on a monthly, on a 6 month, how about semi-annual basis,
How about on a monthly basis? How about on a quarterly basis? That would really cover it.
Don't ask me. It's up to you. This is all up to the commissioners. I don't have any preference one way or the other.
Watch it. Just do a quarterly basis.
Okay,
Yeah, let's do that.
is that okay, Commissioner Fishman?
Yeah, I think it's a little excessive, but I can live with it.
Well, I don't think it would be too hard. All I have to do is see which way are our revenues going.
And on further thought, by the way, I don't think a staff review takes a lot of work.
No,
So my earlier comment, as I think about it more, I'm not so concerned about that issue. So I'm fine with this.
yeah, we just want the information. It should be a paragraph on a piece of paper. So, okay,
Madam
Okay.
Chair, Commissioners,
yes,
Michael Smith, there's one tweak I would suggest, which is right now what the proposal is to order staff to file a petition to review. I think that's inconsistent with staff's role as an independent party in adjudicated matters. So what I think it would be consistent would be to direct staff to bring the matter to the commission's attention. But I don't think it's proper to order them to file a petition to do a specific thing. They can take a position as to what they view is the proper course that the commission should follow, but I don't think we should be directing them in this order.
I win that one after all. Okay.
fine.
Madam
So
Chair,
instead of a petition, it could be a notice of the situation. Which I think would have the same effect. The petition, I mean, requiring a petition that would require staff to take a position with regard to the substance of the program would certainly be a problem. I don't know that it'd be a problem just to call it a petition to review, but it can be instead called a notice of the situation, and then the commission could decide, just as it would on a petition for review, whether to review the matter or not. I don't think it makes a big difference, but we can call it a notice of, basically that the situation, one of those situations has occurred.
I don't think I understood what you said, Russell. Could you just?
Oh, what I said is that that's fine. I can call it what staff would have to file could be a notice that the situation, one of those 4 situations has occurred, instead of a petition to undertake a review.
Okay,
Based on the fact that one of those situations has occurred, we could just remove that part of it. I guess I don't see it as such a problem as Michael does, because the petition wouldn't be staff petitioning the commission to, it wouldn't be staff taking a position with regard to the future of the program. Staff could argue whatever it wants to, as to whether, the circumstances should require termination or not. It would just be a petition saying, it would just be a petition for the commission to commence a review. That's all it would be. But I understand what Michael's saying as well. And so we could just call it a notice. It would just be a notice from staff to the commission that one of these 4 situations has in fact occurred.
and I have a question, Russell. Is there any reason why couldn't notify the commission directly, or at the same time they notify staff? I mean,
No, there's no reason. Any of the options that the commission has discussed are lawful, and the commission can handle it however it likes. Quarterly reporting on the month, on the actual, on just whether there's a deficit or not on a monthly basis, semi-annual or annual reporting of that by the utility, or the utility could be required to file a special report, basically a notice instead of staff, that one of those 4 situations has occurred. Or you can require the reporting by P&M on a quarterly, semi-annual or annual basis of the performance, and then require staff to file a notice with the commission based on whether one of those four situations has occurred based on the reporting by P&L.
Okay. I think
Any of
we're
those
past
options
that.
are acceptable.
Okay, my only question was whether or not it would be okay for the utility to pass the information directly on to the commission or both the commission and staff. But I think quarterly is what we had fixed on. So if that's not a problem, commissioners, what do you think about just reporting directly to the commission from the utility? And they could also copy staff with the information. But I think it's the commission that should get the information. Isn't that what you were seeking, Commissioner Fishman?
Well, again, there's only so much detail that commissioners should be looking at. And then I guess my take is that commissioners should be focusing on policy. And now, if it's directly to the commission, now we have them, executing this stuff. And I really think that's staff's job. And I think after a while, if we took this approach with everything that came before the commission, commissioners would be doing all the work that staff should be doing.
Okay,
So I don't really think that's appropriate.
okay. Any comments? on
Madam
that,
Chair?
Commissioner? Yes.
Thank you, Madam Chair.
Cynthia.
I think the highlight of this recommended decision is reinforcing the rules of how the hearings are taking place and how this particular case was managed. I'm reading on the recommended decision that there's certain stipulated record. There were certain filings outside of the briefing period. And I want to say that our staff, hearing examiner, Anthony Medeiros, I think he has done a thorough job. We go way back 23 years ago. We worked in the same division. And here we are today. His performance as he was starting off his legal profession, it's always very detailed. And I honor that. And many of our staff members that have also come to the table to work for the commission, you will find that there's certain staff members, there's certain attorneys that go above and beyond to talk about the cases that they would like to exemplify the actions that they have taken. And I would like to say that I honor that as well. Just because we are approaching the end of the year, that does not mean that interveners or certain parties will take the helm of our work. That is not the case today. We will continue to review cases up to the final day. We will give the authority to our staff members, our hearing examiners, to fully, thoroughly share their legal perspective, what is going to work, which programs are going to work for the next couple of years to 3 years, moving renewable energy. I think I'm at a point where I would like to work with all utility companies, and I appreciate P&M coming in, submitting their requests, whether to terminate or to continue Sky Blue program. And I think our hearing examiner has given us a recommendation that we will vote on shortly. But I think today is just one aspect of the many series of open meetings that we have held, that we will be guided with the legal process that is appropriate and parties that are listening in on the line. We are here. We will listen to all parties, as Commissioner Fishman indicated, but we will follow the procedure. And that's my take on this particular case, Madam Chair. Thank you.
Thank you, Commissioner Vicente Aguilar. So, Vice Chair Estes, do you have a final structure for this request?
Yeah, well, I think the only amendments to the order is to change the reporting frequency from annual to quarterly. And then I think the language, if you could, I think Russell, you had some language that would direct staff if the trend changes of the Sky Blue program.
Yeah, Commissioner, I can read it right now.
Yeah,
Would you like
please.
me to? So say P&M shall report on a quarterly basis, and then I'll enter, a reference to this particular reporting on whether there's on the monthly deficit or surplus. That's what I add in. Going back to language, and staff shall review P&M's quarterly reporting. And if at any time during the transition period, program costs exceed revenues for 6 consecutive months, or for any 6 months in a 12-month period, or if the regulatory asset balance increases for 6 consecutive months, or for 6 months in a 12-month period, staff shall file a notice to the commission in this docket that such a situation has occurred.
Wait a minute. Why do you tie it to over a 12-month period? That's what we're trying to avoid. I would not say over a 12-month period. I would just say, if they see it increase over a 6-month period, to notify the commission.
It's not, Commissioner Hall, that's not tied to 12-month period, because that's just a different option. So if any of these four, triggers occur, one of which does require a 12-month period, but it's a different option too, because it could be 6 months that are not consecutive in a 12-month period.
Okay, sorry. Fine.
And again, these are what Christopher Hall's recommended. They sound good to me, but there are other options too. But I would guess that at this point, the commission does not want to discuss any other options, because so many options have been discussed.
Madam Chair,
What's your choice?
I'd like to move the order as amended, as Russell just read to us on the record.
I'll second that.
Okay, and that was quarterly reporting upon 2 consecutive quarters.
Mhm.
Okay, we got a motion and a second.
Madam Chair, on discussion,
Yes, sir.
yeah, that's really loud. Like to reconsider our motion. There's a lot of rocks going uphill here. Would you consider tabling this for a couple of weeks?
I don't see why, but it's not my motion.
I know, that's why I'm asking.
Like what's the reason for table?
So there's a lot of misinformation, misconception of what's going on. I think we need our OGC, our council, and ourselves to get better acquainted with all of the issues involved. Not pointing anywhere, but we're being requested to let's talk about this some more. So I'm going to ask that we move that table, that motion to approve, and just table it to the next regular meeting so that we can get a better grasp of what's going on.
No, I appreciate your reason. The only thing is, I don't think these changes are complex. I think General Counsel says they're perfectly legal. They're within our right. So I don't see any other blind spots. We've heard from the hearing examiner regarding the recommended decision. We've been briefed on the exceptions. I don't see any other areas that we need to discuss.
Is this debatable, a move to table?
Well, there's
Well,
already
there's a motion and a
on the floor,
second on
so
the
you'd have to pull your motion.
Yeah, we'd have
for the
to
table.
withdraw it.
Yeah.
Yeah, I seconded. I'm unconvinced to withdraw my motion. I don't know.
Well, again, these are not we've got a lot of bigger issues on
We
the
do.
table. And while I want to respect the move to table, quite frankly, I don't feel a need to revisit this.
Yeah.
Because the dollars are not that big. And it's not to say you don't have good issues here. I just think we've got bigger fish to fry.
So let's take a vote. Can you call the roll?
We have a motion in a second.
Yep.
Commissioner Hall.
No.
What do we?
Thank
No
you.
tabling.
Oh, okay.
Oh, no, this is the motion to approve with amendments.
Oh, okay, then,
Yeah.
yes.
Madam Chair, I'd just like to mention, some of the commissioners and also Michael don't seem to have their microphones on. They're very hard to hear.
Yes, I actually was just made aware that
Sorry.
my mic was off, so I turned it on.
Okay, so the motion and the second to move the amendments, I vote aye.
Commissioner Burt,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Maestas.
Aye.
The order passes as according to the motion.
Madam Chair,
Yes, Commissioner Fishman.
I'd like to thank Commissioner Byrd for being accommodating and willing to compromise. It's not a matter of just getting your way on this commission. And I really appreciate that about all the commissioners. We don't make a mountain out of a molehill. We compromise and move on. So thank you.
Agreed.
So, Madam Chair, if I may, it was only because I kept seeing rocks being thrown uphill that I suggested that, but I'm not opposed to what you're proposing. I just saw a lot of issues that maybe we're missing something. But thank you.
Okay, moving
Madam Chair?
on. What?
I'd like to make a comment as well.
Yes.
I'd like to thank P&M for pushing the renewable energy projects. Although this was a voluntary program, but I think moving forward with the quarterly review that we just approved, I think it's going to be a good program. And the only backside of my decision today is that it is more work for our staff to track this reporting, but I think our staff members have proven to us that they can handle as much work that we asked them to review. So thank you very much, Madam Chair.
Thank you very much, Commissioner Vicente Aguilar. Okay, moving on to the next case, that is item number 8, is case number 21-00083-UT. In the matter of the application of Public Service Company of New Mexico for decertification and abandonment of 114 megawatts of leased Palo Verde nuclear generating station capacity and sale and transfer of related assets, and for approval to procure new resources under 17.9.551 NMAC. Michael Smith will present a proposed order on motion for accounting order.
Madam Chair, I'm sorry, I didn't want to cut you off, but I did just want to bring it to your attention that the person who signed up for public comment today
Oh, yes.
came in actually during the discussion of the last order, Mr. Grady Bailey,
Mhm.
and apparently he made the mistake of following our wonderful MapQuest or whatever computer program and went to the old building. So not that it was his mistake, but I followed it into dead ends myself at times. So I was wondering if the commission might want to give Mr. Bailey an opportunity to make his public comment before we proceed to the next case.
I see no reason why not. Anybody have any objection on the commission here to do that? So do we have to amend the agenda again or anything, or?
Madam Chair, I think that's
procedurally?
just an accommodation to.
Okay, so we can just invite him up. Okay, Mr. Grady Bailey, did I get that right?
Yes, ma'am.
Okay, welcome.
I apologize for being late. I went to circle looking for a building that wasn't there.
Madam Chair, Mr. Bailey, push that red button right on the bottom.
Do you have a red button on there? Yeah,
Yep, there you go.
there you go. Now,
I apologize. My GPS kept me going in circles. So I finally went to the visitor center and they pulled out a map and showed me how to get here. So I use the old fashioned way.
It's always reliable.
Welcome to the palace.
Yes.
I'm glad to be here. My name's Grady Bailey. I'm a former director of the Arizona Energy Office. I actually live in Phoenix. I work for a company called Inclusive Prosperity Capital. We are involved in making low interest loans to people who live in communities that have not been able to get those kind of loans and under the conventional measures. We have, over the past 10 years, through the Colorado Green Bank, Michigan Saves Program, and also the Connecticut Green Bank, we've loaned over $500 million to individuals who participated in this loan program. We have over 1,000 contractors that we've actually talked to and do work for us. We are opening in the Southwest, New Mexico, Arizona, and Texas. And I've been spending a lot of time here talking to the New Mexico lost my train of thought. The New Mexico Solar Association. They do a lot of residential loans, and they do a lot of residential installations. We offer loans to lower and moderate income individuals. We have, again, over 1,000 contractors in those 3 states. Our interest rates are 4.5% to 5.5% for up to 5 years to 20 years. And we'll do a laundry list of different things, including rooftop solar, including battery backup in the homes, EV charging stations, rooftop repairs if your roof's not heavy, it's not strong enough to support a PV solar. We'll also do mold abatement, we'll do windows, we'll do insulation, we'll do all that kind of stuff. And if it goes over $50,000, we'll find other ways of financing. But at those low interest rates, and with the Investment Reduction Act that's coming out from the federal government right now, it's going to send $88 million to the state of New Mexico in terms of rebates for homes. So I've been working with the Energy Office and also NASIO, the National Association of State Energy Offices, to make sure that all that information goes out. Your organization probably is not going to be making a whole lot of decisions with that, but that's just the rebate money. There'll be other money that will be coming into the state of New Mexico. This IRA is over $200 billion that's going to be invested in America to make it more energy efficient and green and clean. I'm not sure if my time is up.
Well, generally we give 10 minutes and I wasn't keeping track. Was anybody?
No, isn't it 3 minutes for public
3
comment?
minutes. Oh, okay. I'm thinking of presentations.
So, yeah.
Sorry. 3 minutes. Yeah, your time probably is up.
I just want to make sure that when the money does come to New Mexico, that every governmental type organization, and you guys do a lot of renewable, there's going to be some community solar money available. There's going to be a lot of utility grade solar money available. I just want to make sure that you're aware of it. And I would like to come back and make a bigger 10-minute presentation at some time in the future. And I promise to be on time.
Well, thank you very much, Mr. Bailey. It's very informative. And if you stay in touch with our office, I'm sure we can arrange another time. Well, I'm not sure we can arrange another time on this commission because our agendas are pretty packed, but check with whomever you spoke to before. Was that you, Mike, or who did Mr. Bailey?
Madam Chair, yes, that was me. I had the pleasure of emailing and discussing with Mr. Bailey the circumstances of today's public comments, and I will be sure to reach out to him. And yes, we will probably schedule a presentation for the new commission. As we are limiting presentations for the next 3 agendas.
Yeah. Okay.
Thank you, Mr. Bailey.
Thank you very much.
You're doing God's work. We appreciate it. Could you leave a couple of cards here?
Absolutely.
Just lay them on the table here and then we can.
Madam Chair.
Yes. Commissioner Vicente, I got it.
Yes, ma'am.
We also have the municipality and the county governments here in Santa Fe.
Yes.
So I think it would be great if you can touch up with those entities. And we also have a municipality co-ops, which is smaller utility companies. And you can Google that as well, Santa Fe, New Mexico, rural electric co-ops.
Okay.
You can also reach out to them as well, I think. But we do appreciate you coming to Santa Fe, and like our Madam Chair indicated, there's going to be a new set of commissioners starting January 1st. Perhaps at that time you can make a longer presentation.
Okay,
Okay.
thank you for having me. And again, I apologize for Google and myself.
Okay. Thank you. Okay, so now we can get to,
Madam Chair, I just also, we actually had changed the order of the agenda.
oh, that's right. We have item number 10. That's right. Okay. So that is case number 22-00270-UT. In the matter of the application of Public Service Company of New Mexico for revision of its retail electric rates pursuant to advice notice. It doesn't have a number here. Michael Smith will present a proposed order on motion for variance.
Madam Chair, Commissioners, yes, I do have my mic on.
Is there a
The
reason?
reason there is no advice notice number on there is because this is a motion preliminary to PNM filing its rate case application.
Are you going to come up to the front table to present?
I could if you want.
Yes, please.
Hopefully my battery doesn't run out. I used to always be up here because we had a bigger table.
Might want to turn that other mic off or use just one.
I just,
Should I go without a mic?
I don't know.
I'll just leave one on.
Okay.
I don't think I need stereo.
It's surround sound.
Yes. 2 more mics for that. So that's the reason that you do. Hello. Okay.
Does that work?
This one seems to be more sensitive. So that's the reason why you don't have an advice notice number on the caption at this time. So the order, the motion that is before the commission right now is the motion from Public Service Company of New Mexico, otherwise known as PNM, for a variance for its rate case filing date and a variance from filing its rate case scheduled for B4, excuse me. PNM's motion is seeking a variance from the requirement of Commission Rule 17-137B that the base period utilized in a rate case. Sorry, I just jumped my screen too far. Which is a historical 12-month period that ends on a calendar quarter, must end no earlier than 150 days prior to the filing of the rate case. PNM proposes instead to file its rate case on or before December 15th, 2022, and utilize a base period ending June 30th, 2022, the end of the second quarter of the year. PNM also intends to utilize a 13-month future test period beginning on January 1st, 2024, the date that PNM seeks for the new rates approved by the Commission to go into effect. In order to comply with the 150-day requirement, PNM would need, sorry, I'm trying to move my screen, to file its rate case prior to the Thanksgiving holiday or on November 23rd, because November 27th is the Sunday following the Thanksgiving holiday, and the commission is closed on November 24th and 25th. However, PNM indicates that filing on November 23rd would result in a future test period violating the requirement that the future test periods start no later than 13 months from the date of filing, stating, quote, filing within 150 days of the end of the base period that ends on the calendar quarter, June 30th, 2022, creates a conflict with the use of a future test period of calendar year 2024, because the future test period would commence 13 months and 3 days later on January 1st, 2022, in violation of the requirement that new rates be implemented within 13 months of the application filing date. For this reason, PNM is requesting, and this is a revision from its original request, a 7-day extension of the filing date to December 5th, 2022. PNM argues that such an extension will not cause the base period to become stale and will allow PNM to comply with the future test year requirement of filing within 13 months of the beginning of the test period being used. PNM initially, as I said, PNM initially sought a 17-day extension, but revised that request to 5 days in its subsequent filing and reply to the responses to its motion. PNM notes that its motion is consistent with recent commission orders granting variances from Rule 17.1.3.7B in cases 16-276 UT, which was PNM's last rate case. That was a 19-day variance. Case 14-00332 UT, which was a 15-day variance granted, as well as variances from the similar requirements of previous Rule 17.9.530.7 F NMAC in cases 273 UT, which was a 29-day variance, and case 10-00086 UT, which was a 2-day variance. PNM's motion also seeks a variance from Rule 17.9.530.14B4B, which requires the filing of base period and test period construction work in progress schedules related to construction work in progress. That's Schedule B4, in support of a rate case filed by an investor-owned utility, quote, when the applicant claims construction work in progress to support a rate increase adjustment. PNM states that it does not intend to include in its new proposed rates any costs related to construction work in progress, and therefore requests a variance from filing Schedule B4 as required by Rules 17.9.530.14B4B. This very long citations in the rule. PNM argues that granting the requested variance would relieve PNM from preparing and filing unnecessary information on costs that will not be included in its proposed rate adjustment, and avoid providing unnecessary documents and information to individuals tasked with reviewing PNM's upcoming rate case application. The motion states that PNM sought the positions of the parties to its most recent rate case, which was case 16-276, as I said, and those parties who responded took the following positions with regard to the motion. The PRC Utility Division staff, REIA, and the Sierra Club took no position, while the New Mexico Attorney General, Coalition for Clean Affordable Energy, otherwise known as CCAE to most of us, and the County of Bernalillo took no position but reserved the right to respond. Subsequently, responses were filed in opposition to PNM's motion by New Energy Economy, Western Resources Advocates, and NMPRC staff. New Energy Economy argues that PNM's motion should be denied because PNM failed to provide good and sufficient cause for its requested variance, because it has not established that a variance is necessary. New Energy Economy relies on Commission Rule 12240E2, which provides that a party seeking a variance must describe the situation that necessitates the variance. NEE argues that unlike its variance request in 16-276, PNM has neither alleged nor presented any evidence that it would be unable to meet the filing deadline without receiving a variance. Any such evidence would be extremely suspect in any event, given the fact that PNM's plan to file a rate case in December of 2022 has been public knowledge since at least February 17th, 2022. New Energy Economy argues that granting the variance will make the base period data more stale, not less stale, and the staleness issue is exacerbated because PNM's proposed rate base does not include the closure of San Juan Generating Station Unit 4, which is a major change to its portfolio. 150 days is the outside limit for staleness under normal circumstances. Here, where the base period would specifically exclude a major shift in PNM's cost of service, any extension which makes the data even more outdated should be denied. New Energy Economy further argues PNM acknowledges that it can use any future test period it wishes, so long as it begins within 13 months of the rate case filing date. Nothing in the Commission's rules requires that PNM utilize a calendar 2024 future test period. Rule 17.1.3.7G only specifies that a future test year period be a 12-month period, quote, beginning no later than the date the proposed rate change is expected to take effect. And there are no facts presented by PNM which support the use of a calendar 2024 future test period. New Energy Economy further argues that the commission should not grant the variance because, quote, PNM has tied the timing of the Energy Transition Act bond issuance for the San Juan Generating Station to the timing of its rate case, and the commission has ordered a prudence review of the timing of the bond issuance. Therefore, NEE asserts the commission should therefore not involve itself in any way in the timing of PNM's rate case, and therefore potentially the timing of the bond issuance to the extent of the requested variance. Western Resources Advocate similarly opposes PNM's requested variance from Rule 17137B, arguing that PNM's motion fails to demonstrate good and sufficient cause. WRA also argues that instead of maximizing the amount of time between its base period and future test period data and hoping for another variance, PNM could have designed a rate case filing package based on a base period ending September 30th, 2022 that included both the shutting down of one San Juan Generating Station unit in late June 2022 and the last unit in late September. Sorry, I'm scrolling down, 2022. Or in the alternative, PNM could have chosen a future test period that began on December 1st, 2023 or earlier. WRA argues PNM has had more than sufficient time and opportunity to plan and prepare a rate filing package that fell within the outer limits allowed by law, recently stating that it was clear from the beginning of case 190018 UT that it intended to file a rate case removing San Juan costs before it issued energy transition bonds. WRA proposes an alternative to the relief requested by PNM and suggests that the commission could grant a variance, providing only a 3-day extension until December 1st, 2022 for the filing of PNM's rate case with a base period ending June 30th, 2022. Neither NEE nor WRA opposed PNM's request for a variance from the filing of Rule 530's Schedule 4B4 construction work in progress. While staff initially took no position regarding PNM's motion, staff did file a response in opposition to both of PNM's requested variances. Staff argues that PNM has failed to demonstrate its requested variances are in the public interest because, quote, PNM is fully in control of when its rate case gets filed. There is nothing in the rule that requires the company to wait the entire 150 days since the close of the base period to file the rate case. PNM has not filed a rate case since the disposition of its last rate case in early 2018 in case 16276 UT. The company has had ample time to assemble the information needed for a filing of this rate case and certainly could file with a second quarter 2022 base period earlier than its proposed December 15th, 2022 filing date, and in fact has not explained why that date is the date on which the filing must occur. Staff also opposes PNM's requested variance from the 17.95314B or B. Wrote this too many times in this motion, in this order. Staff also argues while the company may indeed not plan to include any costs related to construction work in progress in its upcoming filing, PNM's request would preclude the other parties in the proceeding from reviewing the schedule in question. It is not in the public interest for the company to be able to unilaterally decide what issues the parties may review in examining PNM's request. PNM's reply argues that no party opposing PNM's motion has demonstrated how the variances would be contrary to the public interest. And its, quote, motion is a practical approach to resolving a slight conflict for calculating filing dates that exists within the commission's rules, and that PNM's request is entirely consistent with the commission's resolution of this conflict in previous cases. Noting that WRA did not object to a filing date of December 1st, 2022, PNM revised its requested filing date of December 15th to December 5th, 2022 as a reasonable compromise to ensure that rates can be implemented as of January 1st, 2024. PNM argues that a proper and accurate rate case filing is in the public interest. It claims that PNM claims that PNM had ample time. and claims that PNM had ample time to file its rate case within 150 days of the end of its base period are unsupported and ignore the time that time is necessary to assemble the information required for a rate case based on a future test year. PNM notes that it takes time after June 30th, 2022 to verify and close PNM's books and records, which are used as the basis for the base period. In addition, PNM's outside auditors must review and certify as to the accuracy of PNM's books and records. Following this process, appropriate adjustments need to be made to the base period data to reflect the known and anticipated changes that will be in effect in the future to arrive at an adjusted base period. The adjusted base period is then further adjusted and escalated to arrive at an adjusted base period. Just make sure I did not miss a change part here. The adjusted base period is then further adjusted and escalated to derive the future test year to more accurately reflect PNM's rate base operations and maintenance expenses and other costs that will be included in PNM's cost of service for PNM's rate filing. This process involves coordinated work by dozens of PNM employees and several outside consultants and attorneys. As the necessary financial information is being derived, the process of drafting and preparing the thousands of pages of necessary testimony and exhibits begins. During the drafting process, data and information are continuously reviewed and vetted to help establish accuracy. As confirmed in the verification of Mr. Monroy, which accompanied PNM's motion, the original request of up to a 17-day extension is in the public interest because it will help contribute to a proper and accurate rate case filing. PNM argues that any ease argument that the commission should not grant the variance because of unspecified impacts on a future prudence review of PNM's issuance of energy transition bonds is without merit. PNM argues that the de minimis variance requested by PNM and its rate case filing deadline will have no impact on the ultimate filing, rather timing of the issuance of the energy transition bonds, and further asserts that it, quote, will not use the commission's granting of the 17-day variance or the revised December 5th, 2022 filing date as a basis to argue that the commission has somehow approved or ratified the timing of the issuance of the energy transition bonds. Proposed resolution of this is that the commission finds that the PNM's motion for a variance seeking a 7-day variance is consistent in scope and purpose with prior variances granted by the commission, expanding the 150-day time limit of Rule 17-137B. While those parties objecting to the variance assert that PNM's requested variance could have been avoided through the choice of a different base period or a different test year period, no objection identifies how this relatively de minimis variance requested would render the data supporting PNM's application stale or otherwise interfere with the ability of the parties to analyze such data. To the extent that any of the parties object to PNM's selection of its base test period or its future test year period, including based on a failure to include the closure of San Juan generating resources in the base period, those objections should properly be vetted on the merits through an appropriate motion once PNM has filed its rate case and the supporting base period data, linkage data, and future test year data is available for review. PNM's requested variance from the filing of Rule 530 Schedule B4 construction work in progress should also be granted based on PNM's representation that it does not seek to include any construction work in progress to support a rate case and rate increase adjustment. Contrary to staff's characterization that such variance would allow PNM to, quote, unilaterally decide what issues the parties may review, PNM has properly invoked the commission's discretion through its motion for a variance and is not acting unilaterally to deny interveners access to relevant information. Therefore, the commission would order that PNM's request for a 7-day variance from Rule 17-137B NMAC to file its rate case on or before December 5th, 2022 is granted, and PNM's request for a variance from Rule, and I'll say it again, 17.9530 14B4B, relieving it of the requirement of filing base period and test period construction work in progress schedules related to construction work in progress is granted based on PNM's representation and subject to the condition that PNM not seek to include any construction work in progress to support a rate increase adjustment. And I'm staying for questions or sit for questions.
Commissioners, do you have questions for Michael?
I would move the order.
I have a motion. Do I have a second?
Second.
Further discussion? I had a few questions, just one or two questions. For practical purposes, is there any difference between the WRI request that the variance be granted until December 1st and our grant of the variance to December 5th? Is there any practical difference?
The practical difference is only the period of time. December 1st would be immediately following the Thanksgiving holiday. And I believe PNM's request is for the additional couple of days to have its staff be able to put the final application together for filing before it has to, rather than because of the holiday weekend.
Okay, but does it have any bearing on the base period determination?
No.
Okay. And the construction work in progress issue. There was an argument that it would preclude other parties in the proceeding from reviewing the scheduling question. Is there any value in looking at the schedule other than if
My
it
reading of the rule,
contains
my reading of
the
the rule actually,
information?
sorry, my reading, I just sorry, I didn't want to.
Well, I think you understand my question. I mean, why do they want to see the schedule unless it contains the construction work in progress information? Is there something they might be able to discern from seeing that? I just didn't understand why they were making that argument.
I actually did not either. And I also, to some degree, I'm not sure why there was even a necessity for a variance, because the way I read the rule that the information is only required to be filed to the extent that they're seeking
There's some information.
to use it to support a rate increase. So it may not be needed a variance, but PNM, one thing I did not indicate in here is PNM did offer in its response that if staff desires to see that information, it can ask for that information in discovery, and PNM would not oppose that.
Okay, fine, I'm fine. Okay, we have a motion and a second. Any further discussion? Hearing none, Mike, can you take the roll?
Commissioner Byrd.
Aye.
Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Fisher.
Aye.
And Commissioner Hall.
Aye.
The order is approved by a vote of 5-0. Sorry, I was at the very beginning of your tenure at the commission. I was asked to randomize the process. So I usually have my little list and I do mathematical sort of variations on my list the way I write it out. So sort of doing that visually with your.
So, commissioners, it's now noon. The next case is Michael's and he's already in front of us. My question is, do you want to stop for lunch now? And bearing in mind, we had breakfast up until 2 hours ago. Or would you want to continue on and hear Mike's next case?
Keep going.
That's fine with me. That's fine with you. I've got. We could have a 5-minute break for the. Why don't we take a 5-minute break? We'll take a 5-minute break. We'll come back at 12:10.
It'll be difficult. Oh, for goodness. How do you sit with?
How do I sit with what?
Burning enough room for me.
in the matter of the application of Public Service Company of New Mexico for decertification and abandonment of 114 megawatts of leased Palo Verde nuclear generating station capacity and sale and transfer of related assets, and for approval to procure new resources under 17.9.551 NMAC. Michael Smith will present a proposed order on a motion for an accounting order. So Mike, please proceed.
As Madam Chair stated, this matter is, I thought you were just saying my name first.
Can't tell the difference. About what you're doing.
This is much better, but okay. This matter is before the commission on the joint motion for an accounting order filed November 1st, 2022 by Albuquerque Bernalillo County Water Utility Authority, otherwise known as ABCWA, Bernalillo County, the Coalition for Clean Affordable Energy, our friends CCAE, New Energy Economy, NEE, also known in many cases as NE, but we call them NEE, New Mexico Affordable and Reliable Energy Alliance, NMPRC, the New Mexico Attorney General, NMAG, also known sometimes as OAG, Western Resources Advocates, WRA, and the staff of the Utility Division of the New Mexico Public Regulation Commission. Whereupon the joint motion asks the commission to issue an accounting order requiring PNM to track and account for all costs through a regulatory liability account currently borne by ratepayers associated with the 104 megawatts of PNM's leasehold interests in Palo Verde Nuclear Generating Station Unit 1 that will expire January 15th, 2023, and the 10.42 megawatts of leasehold interest in Palo Verde Nuclear Generating Station Unit 2 that will expire January 15th, 2024, in order to preserve the ability of the commission to order a refund if the commission determines in PNM's rate case to be filed in case 22-00270 UT, which we just discussed, that ratepayers are entitled to a refund of costs associated with PNM's expired leases. The basis for the joint movement's requested relief appears to be that the Palo Verde Nuclear Generating Station leases will no longer be used and useful to ratepayers upon their expiration. Am I still going to get an echo? I am. And PNM. Testing.
Michael, I think Commissioner Byrd might be unmuted on his phone. That's the only person I see unmuted on the Zoom screen.
It appears to be coming through the laptop over there. Testing. Okay, sounds like we're good. Going back, the basis for the joint movement's requested relief appears to be that the Palo Verde Nuclear Generating Station leases will no longer be used and useful to ratepayers upon their expiration, and PNM will over-earn by continuing to recover costs associated with expired leases during the pendency of its rate case after most of its Palo Verde Nuclear Generating Station leases have terminated and are no longer being used to serve PNM ratepayers. Joint movement site discussion in the hearing examiner's July 28th, 2021 recommended decision in this case putting PNM on notice that the commission could create a reverse deferral account for any over collections of the costs of PNM Palo Verde Nuclear Generating Station leased interests. As the joint movements note, the commission's September 8th, 2021 order on remaining issues in recommended decision on motions to dismiss adopted that portion of the recommended decision dismissing PNM's request for a regulatory asset for the cost of obtaining an abandonment order with prejudice, while finding that PNM's request for approval to create regulatory assets for rate-making purposes for the undepreciated costs of improvements made by PNM under the leases in Palo Verde Nuclear Generating Station Units 1 and 2 should be addressed, quote, addressed in a full evidentiary hearing together with the other issues remaining in this docket after the bifurcation of the replacement resource issues previously ordered. The RD noted that PNM stated its request for approval of regulatory assets as PNM is requesting that the commission approve an accounting order to allow PNM to record regulatory assets and to recover the regulatory assets through base rates. PNM is proposing to include the unamortized balance of the regulatory assets in rate base, which will earn a return on rate base equal to PNM's weighted average cost of capital. PNM also proposes to recover the annual amortization expense on the regulatory assets as a component of operating expenses in its cost of service studies. In response to the party's motion for rehearing, the commission filed an October 6th, 2021 order on motions for rehearing on motions to dismiss, granting the motions for rehearing. That action thereby vacated the commission's September 8th, 2021 order, quote, so that the commission may have an opportunity to consider the motions to dismiss more fully and issue a new order providing the reasoning of the commission's subsequent decision with greater clarity and specificity. As the current motion notes, the commission has not yet issued an order resolving the remaining motions to dismiss. As the hearing examiner stated in her recommended decision on the motions to dismiss, PNM has nonetheless retained the ability to avoid the need for a regulatory asset. Quote, PNM's remedy is to seek recovery of the cost in a general rate case in which the test year period includes the time period in which PNM incurs its so-called stranded costs. Notwithstanding this, PNM's recent filing in case 22-00270 UT indicates that PNM indicates to utilize a future test year period beginning January 1st, 2024. Accordingly, as PNM's leasehold interest in Palo Verde Nuclear Generating Station Unit 1 expired January 15th, 2023, it appears PNM would be otherwise denied recovery of those undepreciated investments in expenses absent resolution of its request for a regulatory asset for Palo Verde Nuclear Generating Station Unit 1 undepreciated investments and expenses in its favor. PNM objects to the current joint motion for an accounting order, arguing, quote, an order requiring PNM to establish a regulatory liability without a hearing to allow PNM to present its defenses and supporting evidence would violate PNM's constitutional due process rights and PNM's right to a hearing under section 6210(1). Imposition of a regulatory liability would cause PNM financial harm, as accounting rules would require that PNM charge the amount of the regulatory liability against PNM's earnings. PNM further argues that requiring the creation of a regulatory liability would constitute retroactive rate making and piecemeal rate making. Finally, PNM concludes joint movements have not shown or alleged that PNM's current rates will be unreasonable or excessive if PNM continues to recover the costs associated with the Palo Verde Nuclear Generating Station leased interests pending the establishment of new rates to be considered in case 22-00270 UT. In the reply, the joint movements counter that unlike PNM's request for approval of a regulatory asset, which includes rate-making treatment, quote, the joint movements are simply requesting an order that would require PNM to establish a regulatory liability account for tracking specified costs, not a regulatory liability. Citing the commission's discussion of such pure accounting orders in case 15-261, The joint movements countered that, quote, the request by joint movements for the accounting treatment of the expiring Palo Verde nuclear generating station assets is only for preserving the issue for a future rate case proceeding. In case 18261, the commission's final order adopted the RD's identification of the types of regulatory assets that may be approved by the commission. And I have a long quote in here, but I'm not going to read the entire thing, but I will say, accounting orders and regulatory assets are special cases in which the commission has at times approved various forms of rate-making treatment in advance of a utility's expenditures and outside the context of a rate case and its associated test year. The commission has recognized 4 types of regulatory assets. The first is a pure accounting order that does not prejudge the ultimate rate-making treatment of the regulatory asset, deferring rate-making treatment to a rate case. The other types involve accounting orders and various levels of rate-making treatment for the regulatory asset that is being recorded in advance of a rate case. In the words of the joint movements, quote, a regulatory liability is the other side of the same regulatory coin as a regulatory asset. Both PNM and the joint movements ultimately seek to establish their respective claims with regard to the proper rate-making treatment for these costs and expenses. PNM seeks a regulatory asset. Conversely, the joint movements seek a regulatory liability, requiring the refund of costs that may otherwise be borne by ratepayers during the course of the rate case proceeding after the Palo Verde nuclear generating station leases cease to be used for the benefit of ratepayers. As noted, PNM has stated its intent to file its rate case in case 22-00270 UT and has sought the commission's approval for the filing of that case by December 5th, 2024. Accordingly, there remains insufficient time before PNM's rate case is filed to conduct the hearing process PNM asserts is necessary to resolve the parties' respective claims with respect to the accounting treatment for the Palo Verde nuclear generating station investments and expenses in the current case. Moreover, as the recommended decision notes, PNM's own witness, Mr. Sanders' testimony in this case is, quote, PNM believes a general rate case is the appropriate avenue to address these types of changes where the commission can completely assess a utility's cost of service. Therefore, the commission finds that both PNM and the joint movements' respective requests for accounting orders should be approved, but only as pure accounting orders that do not prejudge the ultimate rate-making treatment of those accounts. Determination of the appropriate rate-making treatment with respect to those accounts should be deferred to PNM's rate case in case 22-00270 UT. Approval solely of the creation of the regulatory asset and regulatory liability accounts without any decision on their rate-making treatment will not violate PNM's due process rights. It is therefore ordered the joint movement's request for an order requiring PNM to establish a regulatory liability account is granted, and upon termination of the Palo Verde nuclear generating station leases, PNM is ordered to track and account for all costs currently borne by ratepayers associated with those leases during the pendency of PNM's pending rate case. I think that's redundant. We'll have to take one of those out in such regulatory liability account and subject to a determination of any rate-making treatment, including refund to ratepayers for those costs. PNM is granted authority in the form of an accounting order to create a regulatory asset to record upon termination of the Palo Verde nuclear generating station leases, PNM's undepreciated investment for improvements to its 104.01 megawatts of leased interest in Palo Verde nuclear generating station unit 1, PNM's undepreciated investment for improvements to its 10.42 megawatt unit 2 leased interest in Palo Verde nuclear generating station unit 2, and for any cost differences in the proceeds received from the sale of the Palo Verde nuclear generating station assets and the actual book value of the Palo Verde nuclear generating station assets. PNM's request to recover the regulatory assets through base rates is denied at this time. PNM may seek rate-making treatment of those assets in its future rate case. Consideration of any issues raised by PNM's application in this case that have not been resolved by this order shall be addressed in case 22-00270 UT. This includes the issue of whether PNM's decisions to renew the 5 leases and repurchase 64.1 megawatts of Palo Verde Nuclear Generating Station Unit 2 capacity, which were found to be imprudent in case 15261, exposed ratepayers to additional financial liability beyond that to which ratepayers would have been exposed had PNM chosen to not renew the leases and not to repurchase the 64.1 megawatts of Palo Verde Nuclear Generating Station Unit 2 capacity, and whether PNM should be denied recovery of any future decommissioning expenses as a remedy for PNM's imprudence. I think that was a run-on sentence. Paragraph D, ordering paragraph D would be, in accordance with the recommended decision as part of PNM's rate case, the parties shall also address the issue raised in the recommended decision concerning generally accepted accounting principles requirement, the generally accepted accounting principles requirement that costs that a utility seeks to include in a regulatory asset must be unusual or infrequently occurring, how those terms should be construed by the commission, and whether the costs of undepreciated investments in generation plant being abandoned pursuant to the requirements of section 62.16.1 et sec may satisfy the standard of being unusual or infrequently occurring costs. In addressing these issues, the parties should address what role a utility's participation in planning or promoting legislation that requires plant closures in advance of the expiration of an approved depreciation schedule should be considered, if at all, in whether an expense sought to be included in a regulatory asset may be considered to be unusual or infrequently occurring. Finally, in accordance with the recommended decision as well, as part of the PNM's rate case, the parties shall address whether PNM is entitled to recover its undepreciated investments in light of the fact that PNM no longer owns the undepreciated improvements. And that is the end of that. Stand for questions.
Once again, I will move the order. It's my job today.
Second, my job.
Okay, I have an order, a motion and a second. Can you take the roll? Or any discussion, further discussion? Yes, Commissioner Vicente Aguilar.
Madam Chair, thank you. Michael, can you talk about the leases that they have? 5 leases, PNM. What is their potential plan? Do we have anything in the record?
Well, in this case, the leases that you're referring to are the Palo Verde Nuclear Generating Station leases that were found to be imprudent in case 15261, or rather PNM's decision to renew those leases was found to be imprudent in case 15261. That was PNM's rate case. I believe that was hearing examiner Glick handled that case. The commission, notwithstanding the finding of imprudence, decided that it would continue to authorize PNM to utilize those leases, and but not at the cost that PNM paid for the leases. Instead, it brought those leases into rate base at the net book value. Those leases obviously are leases, and they reached they will reach their expiration point. The first group of leases is on January 15th of this coming January. The second smaller group of leases would be the following January. So at this time, PNM has given an irrevocable notice that it would not continue to use those leases. So PNM's options to use those leases are essentially a nullity at this point. They do not have an option to continue using those leases.
Okay, thank you. Thank you, Madam Chair.
Any other questions? Or questions for Mike?
I'm sorry.
I'm asking the commission if they have any other questions for Mike. Okay, let's see, we have a motion and a second, and I guess no further discussion. And I guess I just have one question I just want to ask as a confirmatory question. The issues of whether the issues that you just discussed, trying to find the right thing, the issues that will be discussed related to the fleshing out of the regulatory liability and regulatory asset will be dealt with in the rate case.
Correct.
Yeah.
Essentially, this is kicking a very large can from this case over into the rate case.
Right, and we have a firm filing date for the rate case. So that should not be a problem this time, right?
Correct.
Okay,
Obviously, if PNM chose not to file its rate case, then this order would essentially be a nullity.
right. If the can would get kicked down the road again. But our assurance is pretty strong that they're going to file a rate case. Our assurance is quite strong that we will proceed with the filing of this rate case this time.
At this point, the docket has been opened and as we discussed.
Oh, they
in the
already
preceding
started. Okay,
case.
fine. I was thinking of the test. I was thinking of the date of the test period. Sorry. Okay, we're good. All righty. So Mike, can you take the roll?
Commissioner Byrd,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall.
Aye.
Commissioner Fishman,
Whatever Commissioner Byrd said. Aye.
and Commissioner Vicente Aguilar.
Aye.
The report is approved by a vote of 5-0.
All right, let's see. Next, we have item number 9 on the agenda. It's case number 21-00177-UT in the matter of a commission rulemaking regarding NMPRC Rule 17.5.440 NMAC, extensions, improvements, additions, and cooperative agreements between or among utilities, and 17.9.592 NMAC, location or large capacity plants and transmission lines. Judith Amer will present a potential order on motions for rehearing.
Yes, good afternoon, Madam Chair, members of the commission. This matter comes before you again upon your own motion to amend rules 440, in particular 17.5.440 NMAC that pertains to the filing of reports regarding utilities, repairs and replacements. And then also amending rule 17.9.592 that pertains to the location approval of plants and transmission lines. If you recall, the commission issued a final order on this matter on October 5th, which made substantial changes to rule 440. So it was a repeal and replace, and then regarding rule 592, one amendment. Then on November 4th, 2022, PNM's EPE and SPS filed motions for rehearing, and there were responses filed by those parties as well as staff and the city of Las Cruces on November 14th, 2022. So this matter comes before you today on the motions for rehearing and the responses, and I'll detail the IOU's arguments regarding rehearing, and the proposed order would partially grant some of their motions for rehearing, which I will show you on the screen when I get to that part. But first, I'll just go through each one of their motions. SPS seeks rehearing of the definition of repair or replacement. They request that it should be limited only to capital expenditures that will be included in a utilities rate base, and believes that the definition now will unnecessarily require tracking and reporting of vast amounts of data related to every small maintenance expenditure. And that's in their O&M budget. And as I will detail later, this is one of the provisions that are proposed to be revised. I'll move on. In addition, SPS requests deletion or revision of the provisions in 448B and 448B2 to remove any implication that a utilities plan construction of a system improvement could be delayed by or disrupted by commission or staff review of a 440 report. This again, as I'll detail later, is one of the provisions that is proposed to be reheard and revised in this order. But their argument is that the way it was currently written, it imposed uncertainty into the utilities management of facility construction. Because according to SPS, it could allow staff to recommend just 15 days prior to the start of a construction project that the commission take unspecified actions. And it created a broad right, according to SPS, for the commission to take any undefined set of appropriate actions. SPS argues this language is unduly vague and overly broad and creates uncertainty. So moving on, the next point is in Rule 440.8E. Regarding amended reports, what they are requesting a revision of the rule to state that an amended report is only needed if the estimated cost varies by the change, either an increase or a decrease is greater than or less than 25%. And as I'll detail later, this is one of the provisions that we are going to grant rehearing on, because as the rule was currently written, it did require the utilities to file an amended report for even $1 over the estimated report, and that wasn't the intention of the rule. So this provision we recommend be revised to if the increase or decrease is greater than or less than 20%, that would kick in the duty to amend the report. But de minimis changes to projects would not require amended reports. And regarding annual reports, SPS objects to the requirement of requiring annual reports for planned filings, and that they note that the projects are often unexpected and require immediate action. That being said, this is not one of the parts that the proposed order would grant rehearing on, because the word planned implies that they're planned and that they're known, and it's not requiring utilities to file about unexpected items because they're not planned, they're unexpected. And next, I'll move on to P&M's motion for rehearing. P&M argues that not only the P&M also objects to the annual reporting requirement, because according to P&M, I'm quoting, not only would this be a burdensome exercise, but it would also effectively require utilities to file 440 reports on projects that don't fall within the rule, presumably to allow the commission to scrutinize projects for which utilities were not required to file 440 reports. P&M correctly notes that both EPE and SPS also object to the annual reporting requirement. All of them object because they believe it will take extensive work, increase cost to customers, does not provide the commission any meaningful information. As I'll detail later, this is not one of the provisions that the commission proposes, that the proposed order proposes to rehear, because but except to the extent that we will clarify in the annual reporting that we are not asking for individual project costs. It's a sum total aggregate amount of all the non-440 reported costs. So it appears there's been a misunderstanding by the IOUs that we're asking for individual project costs. So we're trying to clarify it that we're not asking for numerous small project costs. We just want one sum total number of all the small projects for that year.
So Judy,
Yes.
so presumably it would be as simple as I look at my capital accounts and I pick an account total for this type of capital expenditure, and that's all I need to do to make this report.
Yes, that's the intention.
Okay.
Clearly. P&M also objects to the reporting of planned project costs for the same reasons that SBS objected. However, again, the commission is only requesting planned projects. The ones that are not planned are difficult to predict, and you're not certain that they're going to happen. They would not be in those. It would not be in a report. Third, P&M objects to requiring the filing of a report at least 45 days before construction commences. And they note that Rule 440 in its original form required, which was in 1988, required reporting 30 days in advance of, no, it was actually before 1988. The original form had a reporting requirement 30 days in advance of construction, but in 1988, that was eliminated, but they appear to not have a problem with the 30-day requirement. And so this is one of the areas where the order would grant rehearing on and change the 45 days to 30 days. But P&M also argues that the 45 days in conjunction with the 15 days that staff had to notify of any issues, again, creates uncertainty. And therefore, this also is one of the areas where we're granting rehearing to eliminate the 15-day requirement for staff. And I'll detail that further. Lastly, we'll go on to EPE's motion for rehearing. Their first objection is the burden, increased cost, and delays caused by the proposed Rule 40 amendments. And they object to the pre-review of project costs outside the standard rate case process, and that this rule could potentially direct the utilities to alter their planned capital expenditures. EPE argues that the commission's interference with cost control and project management will affect the outcome of rate cases and adversely impact utilities and investors. EPE also objects to the 15-day timeline for staff to file recommendations or any things that notices about the 440 report, which I mentioned that was going to be deleted. Regarding the staff review of 440 reports, again, EPE, like the other utilities, are worried about the language of staff recommending appropriate action of apparent issues. That was addressed, and I'll show you that that was deleted. EPE also requested clarification of the definition of repair or replacement as it relates to the filing of 440 reports. And I believe that objection is taken care of by the commission adding the word capital improvements. I know that EPE has a particular way of budgeting for blanket projects. That being said, and this relates to the annual report, which we also clarified, as Commissioner Fishman also clarified, which is a sum total of what they call T&D or O&M, and not a single, not listing single individual projects in the annual report. So that being said, at this point, I'd like to do screen share so I can show you what the rule changes may look like, and Robert offered to help. So hopefully,
Robert, do you want to come up? And
okay, well, I'll keep talking. Anyway, first, the commission would partially grant rehearing of staff and the commission review process. The proposed order finds that regarding the issues raised by the IOUs concerning staff review and commission review of 440 projects, it should partially reconsider because of the concerns raised by IOUs that staff and commission might halt construction within 15 days prior to the commencements of an undertaking after the IOU had spent substantial time and money preparing for the undertaking. The commission acknowledges these concerns, although they're not substantiated by any evidence, and I would like to address these concerns to provide assurance. And therefore, it would delete the language concerning the 15-day review process by staff and replace it with language to change it within a reasonable time, in conjunction with removing the statement that the commission possesses authority to take action and require more information. The commission should make these revisions due to the statements of the IOUs that they interpreted it as creating uncertainty in their ability to perform needed undertakings. However, to be clear, the commission is deleting this statement, even though that statement has not changed from the prior Rule 440. It was there, it's there right now. And only to make it clear that the commission does not intend to interfere with the IOU's ability to plan and perform undertakings. Nevertheless, the commission has and has always had the authority under the Public Utility Act and the commission rules of procedure to investigate and inquiry into rate matters to ensure fair, just, and reasonable rates. Regarding the rest of the provisions, regarding staff review, those will remain unchanged because staff has responded that its routine review of the 440 reports currently includes considerations for cost and reasonableness, which is clearly within the commission jurisdiction. The commission is satisfied that by codifying staff's current 440 report review process, for which there were no prior codified procedures, essentially maintains the status quo. Therefore, as you see up on the screen, those are the changes we intend to make. And I stand for questions on this one part. And I have a couple more parts, but we might as well stop here, I think, about this one area.
Commissioners, questions for Judy?
Okay,
I have a question, Judy. I have yellow highlighted stuff in the document you sent us.
yeah,
Is that represented by the red here?
yeah. Anything that's struck out and underlined on what you printed out should be similarly stricken and underlined.
No, I don't have any strikeouts here. I just have yellow highlighting. That's what came out for me.
Well, that's the order, not the exhibit.
Oh, that's the, no, this is the exhibit.
That's the
Is it?
exhibit. I
Yeah,
don't know
it's the
why,
exhibit.
Oh,
I don't know why it didn't get printed. Because
Okay,
in the Word document, it was.
but these are
there.
strikeouts, in other words, wherever it's yellow, it's struck out.
Wherever it's yellow, there were either or strikeouts and underlines,
Okay.
but
Then,
I don't know why it didn't print out.
And then
Okay, I can see a place now. I'll just look at that. That's fine.
I think it's highlighted the changed areas.
Yeah, changed areas.
Uh-huh, yeah.
How it was
We're not
changed, but these are
specifying.
the areas that weren't changed.
Okay. Well, as I said, that for some reason, the Word document does show it, but sometimes you have to change something when you print it out to make sure that it prints out that way. But anyway,
Well, do you want to just walk through just
Yeah.
scroll through it then?
well, okay. As you can see, what is deleted is the sentence B, the commission shall not be precluded from requiring the filing of further information by the reporting utility with respect to its proposed undertaking. And then in C, adding the word undertakings to make sure that it captures the definition, which is if you recall, we changed the benchmarks for filing a 440 report. We raised the limits, and so the word undertaking includes those new raised limits.
I see.
And
Okay.
we deleted the language at the end of 2, if you can see that. In the notification, utility division staff shall recommend appropriate actions to be taken, if any, pursuant to subsections B and C of 440.8 above, as determined by staff at least 15 days prior to the commencement of construction. That appeared from their statements to give rise to uncertainty about the ability of the IOUs to be able to make repairs and replacements, and that was not the intention. So that was deleted, and the language within a reasonable time prior to the commencement of construction or within a reasonable time following the filing of a report on an unplanned emergency undertaking. And then if you look above that, we changed the 45 days prior to commencement of construction to be 30 days. So those are the changes that were made in that section. Are there any other questions?
I thought you were gonna go through all three.
Okay, then, yeah, I'll keep going.
Yeah.
We would partially grant rehearing of Rule 440.9 to clarify that annual reports are sum total aggregate amounts, not individual projects. And I think I've gone through that in pretty sufficient detail. So if you look at 17.5.440.10 annual reports, in D, underlined, we inserted not individual project costs. Hopefully that will make it clear.
Can you move on to the screen there? Are you showing D?
Yeah, it's there.
Oh, I see. It's a little one, little bit. Okay, it's not showing you. Okay, fine.
Moving on, partially grant rehearing on duty to amend Rule 440. As I previously stated, it wasn't the intention to have a burdensome amendment requirement here for estimates that were $10 over. So we made it clear that undertakings estimates that increase or decrease by greater than 20% should be reported. So if you look at E, duty to amend report, we changed it. Before we had a justification process for greater than or less than 25%, and now we have the process for explanations, and that only applies to changes of more than 20%. And if there are no questions, I'll move on to partially grant rehearing regarding the timing of filing of a 440 report. And as I stated above, there's a change from 45 days to 30 days. And partially grant rehearing on Rule 440.7 to clarify that the term repair and replacement refers to capital expenditures that the utility intends.
Where are you located, Judy?
We're
not finding it.
Rule 440.7 definition A.
Oh, yes, back. Okay. Yeah.
Added the phrase that is also a capital expenditure.
Great, thank you.
And for any other matters that were not granted rehearing, the commission states that it is for the reasons filed as described in great detail by the very helpful response filed by the city of Las Cruces. And so the proposed order would make the changes that I've just detailed to the previous October 5th Rule 440 order. It's not making any changes to Rule 592. And in addition, the previous October 5th order required staff to update the 440 form by December 1st, but given the delay in the publication date, we'll change that to make it no later than the date of publication in the New Mexico Register of the amended rule.
Okay, great. Thank you so much. I appreciate it. Okay, that satisfies my questions. And no other questions?
I'll make just
Okay,
a couple of quick comments is that,
yes, Commissioner Fishman.
I'd spent some time with Judy and Robert going through the motions in excruciating detail. You guys know how Judy can be. And
how you can be.
oh, okay. I can take it. I'm a big boy. At any rate, I think all of these changes maintain exactly what the rule is intended to do. I think they have the effect of clarifying the rule, and I appreciate all the utilities and all the interveners who made comments, because I think this does clarify and sharpen the rule responding to these motions. So just to let you know, I think that these are all good.
How to build a better mousetrap.
Yeah. Thank you, Commissioner Fishman. I also think they're very nice. Well, I shouldn't say nice. They're just good clarifications, good questions raised, and good fix on it. So any other comments from anyone?
Yep, Madam Chair, I just wanted to make a general statement that I think when we started talking about these rules, and I think over the course of the last 18 months, it was apparent that we needed to update them, and we've done that. So I think this was maybe overdue, but I wanted to again thank Commissioner Fishman and your staff and working with Judy to kind of get this done. And I think it's a great improvement. So thank you both.
Absolutely.
Thank you. So is there a motion? There was,
I think we have a motion and a second.
I will move to.
I'll second that. Sorry.
Okay, we got a motion and a second.
Okay.
Any
I can
further
take the roll call.
Okay, you're gonna do that? Okay.
Yes,
And we're done with discussion, right? Nobody has any other comments, correct?
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestro.
Aye.
Commissioner Hall,
Aye.
Commissioner Byrd,
Aye.
Commissioner Fishman.
Aye.
That proposed order passes 5-0.
Thank you very much, Judy.
Really terrific work. Thank you. And you,
Yes.
as always, you kept me honest.
Yes. So we'll move on now to item number 11. It's case number 18-00214-UT. In the matter of an order to show cause as to why Rosa Joint Ventures LLC should not be found in violation of the Public Utility Act and commission rules. Russell Fisk on the agenda will be presenting a potential order regarding Rosa Joint Ventures motion. What? Yeah, it's discussion only, that's true, but I take it he'll be presenting this order regarding Rosa Joint Ventures motion for reformation and request for hearing and notice of engineering report, and this is on for discussion only. So Russell, are you there?
Yes, Madam Chair, Commissioners.
Thank you.
Can you hear me?
Yeah.
There is no proposed order at this time, but we're just going to discuss the situation at this time. So I'll just do a brief reminder of where this case stood and and then summarize where it stands and that'll be it for me. So as you will recall, Rosa Joint Venture is a very small water utility that the commission regulates. It's up, I believe, in San Juan County, up to the northern border with Colorado. It's there are, I believe, 2 subdivisions, and also including agricultural use of the water. So there's residential and agricultural use of the water. It's an old system. It's a leaky system. It has problems with, especially in the summer, with water delivery, with water pressure, etc. But a mutual domestic was formed by the ratepayers, Sambrito Mutual Domestic, but that has had many problems of its own. Where things stood, in June of 2012, the commission approved a transfer agreement from Rosa Joint Venture to Sambrito, as is typical in many of these small water cases, especially with troubled water systems. One of the advantages, perhaps the main advantage of such a transfer, is that a mutual domestic water consumers association is considered by the state a quasi-governmental body, which is eligible to receive state money without any concern of violation of the anti-donation clause of the state constitution. So the commission did approve that transfer agreement. As I said, I believe it was June of 2012, and it was expected to close, expected by the parties and expected by the commission, that all of the actions that needed to be taken to close upon the transfer would be completed within 60 days. We are now in November 2022, and those actions have not been completed. The transfer agreement has not been consummated. As you will probably also recall, the 2 central problems with executing a transfer agreement was that there were applications that needed to be made by Rosa Joint Venture or by Rosa Joint Venture jointly with Sambrito to San Juan County to issue a revised subdivision map that was necessary as a precondition to close upon the transfer. And the other action that needed to be taken was that an application had to be filed and in both cases, applications not only had to be filed, they had to be approved. An application had to be filed and approved by the Office of the State Engineer to identify which particular water rights that were owned by Rosa Joint Venture, and there still are owned by Rosa Joint Venture, needed to be transferred to San Benito. Those are still the sticking points. For some reason, after all this time, those things still haven't been done. The commission instituted a daily accrual of fines at one point, and that got them started on the process, but it still hasn't happened. The commission reinstituted fines at one point, but I won't go into all that. I'll say where we stand today, and I'll start by recapping what the commission's most recent order in this matter included. The commission's most recent order was very comprehensive, or was comprehensive. I guess I shouldn't say very comprehensive. It was comprehensive, but it was back in June. But it set some deadlines for Rosa Joint Venture to do certain things. As the commission will recall, the commission has jurisdiction only over Rosa Joint Venture, not over San Benito. San Benito, as a mutual domestic, is subject only to the jurisdiction of the New Mexico Environment Department. But the commission continues to have jurisdiction over Rosa Joint Venture. So on June 15th, the commission issued its order order reinstating accrual of fines against Rosa Joint Venture, ordering Rosa Joint Venture to retain a consultant to complete the processes with San Juan County and the Office of the State Engineer, ordering Rosa Joint Venture to retain an engineering firm to provide an updated estimate of costs of repairs and improvements needed to provide safe, reliable water service, and ordering additional investment in Rosa Joint Venture for such repairs and improvements to the water and wastewater system. And that would be additional investment by its partners, who are also brothers, I believe. The Phelpses, Ralph Phelps and Joel Phelps, I believe. So in that order, that's the most recent order of the commission. The commission, I'll go specifically through the ordering paragraphs, because it's important here. Let's see here. As I said, the commission reinstated fines against Rosa Joint Venture in the amount of $300 per business day, beginning on June 16th, which would continue to accrue until Rosa Joint Venture files in the docket a contract with a consulting or engineering firm that would essentially take charge of the processes on behalf of Rosa Joint Venture with San Juan County and the Office of State Engineer. Specifically, they were to retain a consulting or engineering firm for the specific purpose of completing the processes with the county and OSE necessary to close upon the transfer agreement. Only upon the filing with the commission of such a contract with a consulting or engineering firm would the accrual of the fines begin suspended. Because that's number one. And I'll after I go through these ordering paragraphs, I will describe where the RGV stands on compliance. The second thing RGV was ordered to do was on or before June 24th to retain the services of an engineering firm to provide an estimate of the current costs to make the repairs and improvements to the water and wastewater systems necessary to provide safe, reliable water service to all customers of the systems, and to file a contract with the engineering firm in this docket. Upon receipt of the estimate, there's a contract, then the estimate. The estimate, RGV shall file the estimate in this docket. RGV was also, or the joint venturers in RGV, it's a joint venture. And RGV were ordered to invest in RGV the total amount of the estimate described in paragraph B, which is the estimate to undertake the repairs and improvements necessary to provide safe and reliable water service within 10 business days of receipt of that estimate. And then RGV was also ordered to complete the repairs and improvements described in the estimate within a reasonable time after receipt of the estimate. And the order stated the commission will monitor RGV's progress and may take action upon any indication of lack of diligence on the part of RGV. So going through one by one, where this stands on compliance. The first requirement to file a contract, to enter into a contract with a consulting or engineering firm that would guide RGV or take charge of the processes with the county and with the Office of the State Engineer. That has not happened. What was filed on June 24th, which was the deadline. Let me make sure I'm looking at the right one. It was filed on June 24th by RGV was a engineering contract with Cheney Walters Eccles, an engineering firm. But it was a contract not to essentially take over both of the processes on behalf of RGV. It was to do part of it. Let's see here, what did I do? Well, actually, yeah, it didn't. Actually, didn't even do part of it. So they did that contract with Cheney Walters Eccles was not to do what they needed to do. To take over the processes with the Office of the State Engineer and the San Juan County, but it was a contract to do the second thing that they were required to do under the order, which is to undertake a study of the systems, what repairs and improvements were needed, et cetera. So that's part of what needed to be done, but I don't think they ever entered into any kind of agreement with a consultant or engineer to guide them through those two processes, the one with the county and the one with the Office of State Engineer, were the sticking points. And as you will recall, as I said, one of the main points of doing a transfer to mutual domestic is to be eligible. So the mutual domestic is eligible to receive state funding. But the amount of funding that was requested by San Vito and actually was granted by the legislature a few years ago, conditional upon the transfer happening, was, I believe, about $20,000, I want to say. And as the commission will recall, there had been an engineering report by Souter Miller from a few years before, estimating the costs to make the necessary repairs and improvements to the systems, water and wastewater systems, at over $1 million. So even if the transfer agreement had been fully closed upon, and the transfer were complete, the money was scheduled to come from the legislature wasn't nearly enough. I don't know why somebody asked for so little. Certainly $1 million, as some commissioners noted, $1 million would probably be too much to get from the legislature in one fell swoop, but 20,000 was far short. So that's one of the many mysteries of this case. But of course, that was never dispersed anyway, because the transfer still hasn't been consummated. And so that $20,000 expired. It's no longer available. But going back to the compliance or lack of compliance by Rosa Joint Venture with the June 15th order, as I said, first of all, RGV did not enter into any kind of agreement with any consultant or engineering firm to basically guide them through the processes with OSE and with the county. And that was compliance with that provision of the order was what was required to stop the accrual of fines at $300 per business day. So those continue to accrue. As I said, RGV did enter into this engineering contract with an engineering firm. And recently there was some more recent activity there, which is that let me get the name of this engineering firm before Cheney Walters Eccles, I'll call it CWE. They did actually, that engineering firm did issue an engineering report and an estimate for the costs to improve and repair the water and wastewater systems. So on November 14th, it was filed. I filed this in the record. It was provided a bit earlier, but this is another thing. RGV is not filing things in the record anymore. They just email them and to me, and I filed them in the record. So there was an engineering report issued by CWE. The date of, let me see. Okay, I have it in front of me. On October 24th, in which CWE did provide cost estimates. Now, these cost estimates are limited to those repairs and improvements that are needed to the water and wastewater systems on what they call short term. These are all short term. That's how they put it. I didn't see an explanation of what they meant by short term, but this report provides a summary of short-term water infrastructure improvements that are needed.
No, say
Yes. I heard someone speak. Okay. And the total cost there, now, for the short term, the estimate for the total for the short-term water infrastructure improvements is $180,000, $180,500. That's for the water system. So it's a lot less than the over 1 million that was previously estimated by Souter Miller, but presumably the earlier estimate of over 1 million included long-term improvements. And I don't know what short-term means versus long-term here. But there's also wastewater or sewer system, and the CWE estimates $70,000 for the total costs for short-term improvements. So you have 180 and 70, 250,000 is what's estimated. Again, these are what they call short-term improvements for the system. I don't know if they looked at long-term improvements or what. There's no explanation. So that's where that stands. So that was complied with in the sense that, you know, they did retain this firm. That portion of the order was complied with. That portion of the order doesn't have anything to do with the penalties that continue to accrue, but they undertook that. Now, within, as I said, within, I believe it was 10 business days of that October 24th report, the joint venturers and RJB should have committed additional investment to cover those costs, $250,000, and then began to undertake the actual improvements. Actually hire, I think, CWE to make those improvements. And there's no indication that they did. Instead, they didn't file, but sent in, Rosa Joint Venture did, a motion. This was on a motion for reformation and request for hearing. This is by Rosa Joint Venture alone. It's opposed. I believe it's it's not opposed by Sembrito, but it's not joined in by Sembrito. So I don't know what Sembrito's position would be in this. But to get to the gist of it, they're asking for something the commission can't do. They're asking for equitable reformation of the transfer agreement and the financial liability of the RGV partners. The financial liability of the RGV partners was something was set in an order, the order that I just mentioned from June. So that's not part of the transfer agreement in any event. The transfer agreement actually had more limited repair, set of repairs that RGV was responsible for. The commission's order went beyond that. But equitable reformation of an agreement is a power that the commission does not have. That's a power that the courts have. The commission has no power over contracts, over contract law. The commission only has the power where it's necessary under the law to have approval of the commission. The commission only has the power to approve or disapprove a contract. The commission doesn't have any traditional contract powers or equitable powers over any contracts. Those remain with the courts. The commission can't decide when a contract has been entered into or when it hasn't, well, whether it's been performed or not, for the purposes of damages or anything like that. Those are all powers of courts. The commission, has, of course, the power to influence the content of an agreement before, by letting the parties know that the commission will not approve something, an agreement, unless it has certain conditions, has certain terms in it. But that's really sort of as an unofficial power that stems from the commission's power to approve or disapprove. The commission certainly cannot rewrite a contract, which is what equitable reformation means. And there are a number of reasons given by RGV. They say that the partners in RGV have been in a legal battle for a few years. This protracted dispute has created challenges for the partnership and affected its ability to comply with the mandate of the June 15th order. In other words, they're not going to add more investment to cover the costs of repairs. After the engineer, I'm reading from the motion again. After the engineering report was issued, RJV contacted Judy Phelps's counsel. That's the wife of one of the brothers, I believe, and requested information about compliance. Judy Phelps's counsel. See, I believe there were two brothers, and this is coming from one of the brothers who's generally run RJV, coming from counsels for RJV. So there's this dispute between the two brothers, as I said. RJV proposed to secure a loan with RJV property as collateral. Judy Phelps refused. The pending partnership lawsuit prohibits RJV from conveying or encumbering any partnership property without the consent of all partners. Ralph and Jean Phelps cannot independently obtain a loan due to their credit score. Judy Phelps has not consented to using RJV property as collateral for a loan. RJV is at an impasse. RJV continues to support transferring the system to a mutual domestic water consumers association, but the terms of the transfer agreement must be reformed. Ralph and Jean Phelps cannot continue to operate the system without any financial assistance, and they cannot independently obtain the funds identified in the engineering report. In other words, to cover the costs identified in that report. Ralph and Jean Phelps also cannot encumber any partnership property without the written approval of Judy Phelps. RGV respectfully requests that the commission set a hearing for the purpose of taking evidence to provide for equitable reformation. And again, that's something the commission cannot do. Staff.
So excuse me, Russell, can I ask you a question?
Yes, Madam Chair.
Or what are you reading from? The motion?
The motion, yes, the motion that hasn't been filed.
I
But
noticed that.
I'm going to file it in the record.
Could you please send us a copy of that?
Yes,
I mean,
definitely.
I would like to have seen that last night even.
Yeah, I'm sorry, I didn't, because I didn't do, usually I would do this.
Excuse me, Russell. The only thing we got was the letter, and it would be useful for us to be able to look at that motion while you read it. So please send it to us.
Yes, I'll do that right now. Sorry about that. Usually I would just do a summary memo of all this. And that was one reason why I was considering, why I asked the commission to consider taking it off the agenda. But since we are going through it, I should send you these things, obviously. Sorry about that.
Yeah. Do you need a copy? Oh,
All right, I just sent that through. Might take a minute. And it's actually, I was finished from reading from that. But if you like, it's brief. Commission would like to review that, and of course, give you a second. Let's see. So,
Russell, can you arrange to get that put in the record? I mean, it seems like something.
yes, I'm going to do a notice of filing on that, Madam Chair. I've done, if you look at the file, I've done notices of filings on most everything for the past few months, because for some reason, even though RJV has an attorney, she doesn't file these things in the record. She just emails them to the parties and to me.
She needs to be instructed.
It's interesting that yes, we can, as the commission should direct that. But I don't know, this case has been going for years, and the attorney was filing things in the record and seemed to know that she needed to do that. And I don't know, I don't know why that has changed. But the behavior of most of the parties in this case, or of the two parties in this case, is a mystery.
Let me ask you a question, Russell. I have a question for you, if you don't mind. I noticed in one of our other cases, we were having a referral to the AG for looking into a unfair trade practice violation. Would there be any reason for us to try to refer this matter to the AG for specific performance or something? I mean, I can't really picture what on what basis, but do you have any thoughts on that?
Madam Chair, that is something the commission has discussed in the past. I'm trying to recall, I'm looking at the record to see whether the commission did so or decided not to do so on this, on the basis of what you're just talking about, that we couldn't think of a reason why they would do any better, essentially. I mean, because the situation we have is that we have a transfer agreement that's a good agreement, and it's approved by the commission, and it's a complete mystery why these two parties, is in both of their interests,
So
have not completed those two things they need to complete. And this motion for reformation also,
Russell,
I believe, doesn't address that.
Russell, let me ask you, are the users of this water system getting water now? I mean, what's the level of their service now? Do we know?
We don't have any actual evidence in the record, because we have emails that are sent, but those aren't evidence. So they really shouldn't be considered, but I'll open the most recent one, see what it says.
Did staff do some sort of a survey of their level of service at some point?
Not their own survey. They just have sort of reported on a long time ago what was being said in the emails.
And we received no complaints from any of the customers?
Yes.
There was a complaint which prompted this entire process at the beginning, that's why this became an order to show cause. And we continue to receive emails. I don't remember if another formal complaint was filed, but this whole thing started with a complaint because the commission wasn't even aware of the existence of this water system.
We imposed fines on somebody, both these parties, I thought, at one point, or at least one of them. Is that correct?
Yes, a number of times. In fact, as I said, I would say that they continued. They were at one point there were fines that were instituted that were accruing by business day.
And nobody did they pay anything?
Nothing's been paid, but it hasn't been. The commission hasn't ordered payment of any penalties yet. Has only said when they accrue, because the fines that have been imposed have been daily fines to encourage the parties to accomplish a particular result.
I hear you. I understand.
And they
They-
continue to accrue, as I said, they continue to accrue at $300 per day, per business day since June 15th against
I-
Rosa Joint Venture, because they have not contracted with a consultant or engineering firm for the purpose of taking over those processes and making with the county and the Office of State Engineer.
Okay,
I don't see any explanation anywhere of that except that they,
I
you
understand.
know,
I understand. So, in that case, since we have imposed penalties that which are accruing and quite a bit of time has passed since we've done that, and they're not reacting, isn't there something in the statute that permits us to seek assistance from the Attorney General's office in enforcing our orders?
yes, I believe that if a commission wants an injunction, I believe for an injunction, I think that's what we can do. But when it comes to collecting money, I don't believe the commission has to go to the Attorney General for that. The commission could just issue an order saying that the accrual as of today of fines over the course of this action is such and such, which is, I don't know what it is, could be up to $100,000 by now. I have no idea. Don't quote me on that.
Can you, well, let me see. All right, fine. So that's to me, it looks like that's our only recourse at this point. We are our order is being flaunted. The parties are not complying. This whole case initiated with a complaint as to service. And
I'm sorry, Madam Chair, the complaint noted that the RGV has never had a certificate, a CCM, and has never had its rates reviewed or set by the commission.
Okay.
Or approved by the commission. And so there was an order to show cause, which came out of that, as to why RGV should not be found in violation of the Public Utility Act, et cetera, for that. And eventually, it was assigned to Ashley Shanauer, and very eventually, after you had postponed the hearing about 12 times, the transfer agreement was stipulated to, by which it would go to Sembrito, and then Sembrito wouldn't need a CCN because we do not regulate mutual domestics. And transfer agreements seem to be the solution, as it is in many cases, but it was for the reasons I've discussed, it was never consummated.
okay, well, in any case, Sembrito Sembrito doesn't own it yet, right? That would be correct.
And there have been lots of
And Rosa Joint
attempts-
Ventures is subject to our jurisdiction right now, right?
Yes, exactly. Yes.
Excuse me just a minute. Commissioner Maestas, did you have a comment?
Yep. Madam Chair, I think going through the long history, I think was good to refresh our memories, but we don't really have anything to act on in the way of a proposed order. And I do believe we should heed staff's request to act on this motion for reformation and request for hearing when it's filed. What I would suggest, Madam Chair, is that maybe you and I work with Russell on this and come up with a draft order between now and November 30th, which is, I think, what our original plan was completely just defer this until November 30th. But given the nature of this case, it's my dream to tie this up in a nice bow, and maybe this action on November 30th can help do that. It's not going to change the situation on the ground appreciably, but I think for our purposes, maybe we can come up with some conclusions, some concluding actions from our standpoint.
Well, I'd be willing to do that, but I thought I heard Russell say something about we lack jurisdiction to create a reformation. Did you say something like that, Russell? Because I didn't get a memo from you or anything, but is that what you're telling us
But
today?
that's why we need to deny it, because we can't do it.
Deny what? What's the request? I don't even know.
What's
Oh,
the-
staff's request. Okay.
No, the filing from,
Yes, their motion.
Madam Chair, I think that sounds like a good idea from Commissioner Maestas. There are a number of different actions. I will recommend denying the motion for reformation because we don't have the power to do that. Staff has filed a response. They oppose the reformation. And so, but there are other, what actions do we take then? I think is the question that I think would be, it makes sense to discuss. Outside of an open meeting or in the open meeting, but if the commission would like to proceed on to other matters, I think it does make sense. I can work with Commissioner Maestas and you, Madam Chair, on some
Totally agree. Yes.
other possibilities.
You gonna make a motion?
It's discussion, so.
Okay,
Yeah, no motion is needed, Madam Chair. We'll just, I'll reach out to your offices about this.
thanks, this discussion. Okay, fine. Thank you very much. Okay, thanks. Okay, thank you, Russell, for all that detail that we got a review on. Moving on, we'll go to, wait a second. I assume no other commissioners have any discussion on this. Is that correct? Anybody, anything else? Okay, we'll move on to the next case, which is we'll need to go into executive closed session at this point. The case that we will consider is 21-00114-UT in the matter of El Paso Electric Company's application for approval of its 2022 to 2024 energy efficiency and load management plan, utility incentive and revised rate number 17, efficient use of energy recovery factor. And in that closed session, Robert Lennon and Russell Fisk will conduct they'll present that matter to the commission and we will have a discussion regarding the recommended decision. Robert Lennon will present the recommended decision. And going into the closed session is pursuant to New Mexico statutes annotated 1978, section 10-15-1 H3 pertaining to deliberations by public body in connection with an administrative adjudicatory proceeding and will be in accordance with that statute. So we will now go into executive closed session.
Madam Chair,
Yes.
I know we have a standing policy to hear recommended decisions in closed session. I thought the condition was that we would do that under a contested RD. And I don't really see that there's a strong resistance or opposition to the RD. And I'm wondering if we do in fact need to go into closed session.
Is it contested or not?
There were exceptions.
There's exceptions.
Okay. Oh, well, I think it's constructive to go into closed sessions, but we could discuss that then.
Madam Chair.
Yes.
So I agree with Commissioner Maestas there. I think we could do this in open session.
I agree. I think the issues are very clear here and
Okay. Commissioner Vicente Aguilar?
Yeah, I think this is a good idea to inform everyone that's listening and paying attention to this meeting that the discussion that we want to discuss should be open to everyone. Thank you, Madam Chair.
Okay, fine, let's do that then. So we won't go into executive closed session. And hearing examiner Lennon, could you please present? Thank you.
The record's Robert Lennon. It's really nice to be here.
It's great to see you in person.
Yes.
Waking up and being asleep for a couple of years. I have been watching the meetings on YouTube in my office. At first, I started joining the Zoom. Then I stopped zooming in, but I'm still always here, even though you didn't see me very much. It was getting back to this case, if you will. It was my understanding this would be in closed sessions. It would have been my first closed session proceeding. So somewhat looking forward to that. I hadn't done one with you guys yet. I'm perfectly fine presenting like this. Anthony was in the room. You know, had discussed that this would be in closed session. There were exceptions filed by the city of Las Cruces. They were responded to by other parties. The case today, or the presentation today anyhow, is not about the exceptions. I understand that Russell Fisk will be addressing the recommendations next week.
Robert, just a real question for Russell. Russell, if we asked for you to present exceptions today, would you be able to?
Commissioner Fishman, no. As I said in my memo, because I was relying on the usual procedure, I'm not prepared to discuss the exceptions. I'll bring them back with a proposed order on November 30th.
Okay.
Today was just for discussion of the RD, whether in closed or open session. I think it's just, yeah, so I'm not prepared today. Sorry about that.
Okay, and as I said, the issues here are pretty clear. So if we would focus on any areas of controversy,
Well,
that might help move things along.
yes, I'm going to try to move along, despite what you've seen so far, as quickly as humanly possible.
Okay.
I only have a 5-page executive summary, which I entitled Introduction and Summary.
Great.
I really think it digest is the word, but it condenses the entire proceeding into just 5 pages, some just single line
Right.
paragraphs. My file in my office is about 10 inches thick. This is just the post-trial, post-hearing briefs and other things. So I'll just dive right into it with your permission. I'm going to, do the commissioners prefer that I share the screen so that people at home can read along?
Yes, that's good.
I have to get right off my dinosaur to start this up. But oh, host has disabled screen sharing. Is a host here? Is that Patrick?
Robert, go ahead and share. You're good.
It's really not all that exciting, but I understand that people on YouTube might be interested.
Well, we do have some entertainment standards here.
Right.
You can't
As
just
do
ignore
I.
them. Yeah.
I tried to get this set up before we it's pretty good. Pretty good twang there.
Now,
Right
was
on
that
chin.
Isn't that Jeffrey?
Just a moment, please. Sorry.
Getting jiggy here.
I don't have. So I'm jiggy.
So you started trying kind of loose, kind of informal.
Loose and informal. Got it.
Yeah, let's see.
Yeah. I'm a bit technologically challenged in some ways. I can just barely conduct my hearings by Zoom, but I've gotten better through the last 2.5 years or so.
And which one did you want to? We can just do this screen like that.
Thank you. I have it up on the screen.
Is it this Adobe?
Yeah.
Cover?
Yes, sir. Thank you. So I have to scroll down through these. All right.
So sharing.
Yeah. So it's not just me. Try new share, see what that does.
Says low system resource.
Thank you, Miguel. Well, that was already 5 pages worth of time right there. But he's setting me up here. I'll try to not waste too much more time. This really is a relatively simple case. This is a filing, a regulatory compliance filing, really. And frankly, some interveners try to turn it into something other than a regulatory filing. I'm not saying that they should not have, not directly saying that, because they can do what they can do. I already identified myself. I'm just going to move on to. I need to do two things at once, run this screen and read off my paper are difficult. And I'll just read off the screen. So it is helpful, and it's even helpful for me. I reviewed this file yesterday. I reviewed it last night from 11 to midnight. I reviewed it this morning between 8 and 9. Sorry, I missed the burritos. And then I was reviewing it while I was sitting here. But I'll go through it again, and I think reviewing the law behind it, and we have regulations, rules as well, and that is part of the controversy, is important, especially for people who don't do this every day. I handle all different kind of cases. This is in particular related to the law, which is called the Efficient Use of Energy Act. I'm sure you're familiar with it, but maybe not everybody that's monitoring by YouTube is familiar with it. The act provides that utilities shall conduct cost-effective energy efficiency and load management programs and provides that disincentives to development of such programs may be removed, balancing the interest of the public, ratepayers, and shareholders. Now, that's a lot of words, but what it means is the utilities shouldn't suffer any financial detriment by trying to follow the legislature's mandate to reduce energy demand and consumption. I hope that was just a little more clear. Utility companies such as El Paso Electric are to acquire cost-effective, achievable energy efficiency and load management programs using their best efforts. When I say are to, that means the legislature says that you shall. And that is in fact the case. The programs are subject to commission approval. That's us. Or you. Plans for such programs are reviewed by the commission every 3 years. This kind of a case. This case is such a review, pardon me. The law allows a utility to recover the cost of its energy efficiency programs. Oh, thank you, sir. You guys are great. The law allows the utility to recover the cost of its energy efficiency programs. EPE utilizes a rate rider. El Paso Electric Company has applied to the commission for approval of its 2022 through 2024. That's 3-year energy efficiency and load management plan, utility incentive, and a revised rate, number 17, which is an efficient use of energy recovery factor. This is all to move the money around, if you will. The current plan was first approved in case number 18-00116-UT on March 6, 2019. Then again, on July 22nd, 2020, the commission granted EPE's motion to modify its plan to add a residential load management program. I'll try to move on without defining all these terms, because I believe the commissioners know all this terminology. Much of the proposed plan is a continuation of the previous plan. That's what I meant by this isn't that complex of a case. There's already a plan. They added 2 new programs, simply. Much of the, well, it's a little more than that, but I'll go further. Much of the proposed plan is uncontested, and that's important too. Much of it is uncontested. The portions which are contested will be examined below. Approval of the plan is recommended by me, recommended by staff, and not opposed by other parties, some other parties. EPE proposes to include in its 2022 through 2024 EELM plan the following cost-effective programs, which continues previously approved programs with 2 additional programs. The 2 additional programs are the marketplace and energy smart programs. In the interest of moving things along, I won't recite them into the record. They're on the screen. As required, the plan satisfies the efficiency test. There's law. I have it under my left hand somewhere. The act, and it requires the utility cost test, which means that it costs less than the energy it saves, essentially. And that's a factor of, it's like a numerator denominator fraction. Anything above 1 indicates efficiency. And for the years 22, 23, and 24, the projection is 1.49, 1.52, and 1.55. These are significantly above the 1. This is beyond doubt anyway. Well, I wouldn't say beyond doubt, but it's well-founded. Satisfaction, it also requires satisfaction of the efficiency test requires a figure greater than 1. As required, efficiency measures are available to all customers in each rate class. That's to comply with the statute. An analysis of administrative costs was presented in the case by the EPE witnesses. It's dense data. We get to the point. A projection of consumer participation in each program was presented. Proper notice of the application was published, no problem. So these are complying with the statutory requirements. EPE requested a variance from existing rule 17.7.2.8 C1 and 8E to authorize EPE to carry forward its 2020 program year overage and collect it through proposed rate number 17. That's the rate which was filed with this action. They requested that it be above, and there's a typographical error there. It should be above the then current rules 3% funding limit. What happened is the legislature increased the limit to 3.25%. Our regs caught up only after the filing of this proceeding. So they just wanted it to be what our current regs are. And I've recommended that variance be granted. It just makes perfect sense. Next page, number 4, we're almost on 5. EPE contended in its application that the annual program budgets for the plan over an extended period 2021 to 2025 are within 3 to 5% funding level of the 2020 revenue as required. Those words as required are important because they tie into the statute again. It's one of the most confusing sentences I've ever read, to be quite honest with you. But 225 has to be a percentage of 2020. That's what it says, and they comply with that requirement as well. EPE promises to report to the Commission the annual reconciliation of collections and expenditures, overages, and deficiencies, and the incentives. They had a report, period. EPE seeks to increase the amount authorized in rate number 17 from 3.079 to up to the new proposed rate of 4.5914. This is the money. This is where the ratepayers see it on their bill. EPE contends that this change would cost the typical residential customer a 1.5% increase on their monthly bill, which is about $1.24. EPE seeks approval of its 2020 reconciliation, which includes an overage of $902,001, an incentive of $381,102, and a base rate administration of costs of $222,941 that are not recovered through the rate. So this case, as you can hear, it kind of changes into a quasi rate case. They're not dealing with the base rates, but they're changing a line item on the bill. So it smells rate-ish, if you will, because of those requests. There was a bit of controversy over the rate increase, but it hasn't worked out, as I believe addressed a little bit further. EPA seeks authority to modify its 2023 and 24 budgets based on 2021 and 2022 revenues, and authority to shift among programs within the 10% provided in the controlling NMAC rule. This is really not very controversial. The plan was developed after soliciting input from interested parties as required, including the AG's office, CCAE, and the city of Las Cruces, as well as commission staff. These are required. This was required. EPA seeks approval to continue recovery of the performance-based incentive approved by the commission in case number 1816 UT for the plan year. for the years of this application. Specifically, EPE requests $410,930 for each year of the plan, subject to true up based on the actual expenses and actual savings. I want to comment that $411,000 is relatively small compared to the gross figure of this entire project. These are for 2022, the gross figure is about $6 million, 226 to 6.2 million. So it's a large program, and this is there to take away the disincentive as authorized by the statute. Moving along, EPA reconciled its 2020 plan year expenditures and collections, included a 2020 utility incentive. EPA now seeks approval of the reconciliation. They want their money that they're entitled to. An overage of $902,001, a 220 plan year utility incentive in the amount of $381,000. There's a formula where these figures come from. There's a lot of formulas, actually. Like I said, it's some dense data. C, $227,942, a base rate administrative cost, not recovered through this rate that they're suggesting. EPA contends that the total funding amount for the proposed programs for plan years complies with the statutory limits in the amount that is not less than 3% and not more than 5% of EPA's historical 2020 total retail kilowatt hour revenues. And you don't want to burden you with all the data, but there's numbers that go to that, the total retail out revenues, and there's a percentage applied. So that's how those numbers get crunched out. Commission staff reviewed the energy efficiency plan and found it compliant, cost effective, and consistent with the energy efficiency policy. Staff economist Christopher Dunn filed direct testimony and generally recommended approval of the EPE plan with additional reporting requirements that did not oppose the requested variance. So staff agrees with basically everything except for the reporting requirements. There was one other thing that I could have put in that paragraph. They decided to split the overage. Well, they proposed to split the overage recovery between 2 years to avoid rate shock. And in rebuttal testimony, EPA conceded that, but that's not in controversy. Protests were presented by the city of Las Cruces and pro se litigant Philip Simpson. They argued that the cost effectiveness of programs should be evaluated on a measure level rather than the broader program level. And frankly, that's in direct, this is for Russell to deal with next week, but it's in direct controversy, contradiction with the statute. What, I read that as trying to legislate, which is those guys in the big roundhouse before me, which is the litigation level, and then before you, which is administrative level. And anyhow, that's they want to change the law, basically.
So
Yes, sir.
a quick question. When you say on the measure level, that means the UCT on each individual
Precisely.
element needs to be over 1 as opposed to the entire program.
Precisely. And I'm not saying that that's better or worse, but that's not what the law is.
Certainly hasn't been what's been done in the past here. So, okay,
Anyhow,
thank you.
thank you, sir. Ooh.
And perhaps if I may, Madam Chair,
Yes.
maybe it's
Commissioner
because of
Myers.
the addition of the two new programs. Maybe the protestants wanted some kind of initial individual evaluation for the new aspects of the program. I'm just guessing.
Their pleadings, they're not objections and not protests, the exceptions. They have, if you will, pet projects. Once Mr. Simpson believes that LED lights should not be promoted any longer, for example. And pardon me if I look at my cheater. The city the city, and I'm giving a preview of what Russell is going to deal with next week. But the city had somewhat of a discovery dispute and feels that there was not enough information provided in the filing in order for the city to evaluate whether the UCT is high enough on a measure rate. Not that that would be relevant because the statute doesn't make it relevant, but that's one of their pet things or contentions. They didn't prove through evidence, by the way, that enough information wasn't provided. And I decide the case is in my recommended decision based on the evidence. If they didn't present evidence of it, I'm not deciding it, and they didn't present evidence of it. But like I said, I'm looking ahead a little bit further. So it's Commissioner Maestas, it's more they have their pet interests that they pursue when they can, and they could here even on this administrative compliance periodic filing because they intervened. And they pulled out of their baggage their interest and presented it, and frankly complicated, if you will, this case more substantially than it would have otherwise been complicated, and continues to be complicated because we have to deal with the exceptions as well. So I'll try to move along. Protests were presented by the City of Las Cruces and pro se litigant Philip Simpson. They argued that cost effectiveness of programs should be evaluated on a measure level rather than the broader program level. No persuasive evidence or legal argument to support the position was presented during the proceeding, during the administrative litigation. The application should be approved. This hearing examiner, me, recommends that the commission adopt the following statement of the case, decision, finding facts, and conclusion law, and decretal paragraphs in its final order. So that's as succinct as I could possibly make a not quite succinct case. Any questions?
Commissioners, any questions for Mr. Lennon?
None.
None. Thank you, Commissioner Byrd. And I
Vice Chair
voted
Maestas, any questions? Commissioner Vicente Aguilar, any questions?
I'll make a
Mr. Byrd?
quick comment though.
What's that?
yes,
I'll
sir.
make a quick comment. I think, pending we're hearing the exceptions, it seems like you followed the law here just fine. It's just how I read it. And I just personally, I hate this law. I think it's the dumbest thing in the world. And I think the idea of compensating utilities for running a program that they shouldn't be running anyway just seems stupid, but that's the law. And I think you've interpreted the law, and thank you. I think you've done a service by doing that.
Thank you for being grateful.
You
I
stayed
appreciate
true
that.
to it.
That's all I really can do, unless be reversed on appeal, that kind of thing. And I do the best that I can. I appreciate your gratitude. And thank you all.
Yeah, thank you very much. Very concise.
Congratulations, Commissioner. Thank you.
Okay,
Have
So-
excused.
yes, you may. Thank you very much.
Very much, Chair.
I beg your pardon.
You asked if you could be excused, and I was sitting there saying yes,
Okay.
but that's your job.
Well, that's all right. I think it
I
makes,
can swallow that word. Can I take it back?
I'd like to see it. Okay, we're on item number Roman numeral 10, discussion and potential action.
Everybody left.
Oh, wait a minute. What happened to Wayne?
Where's our
This is his
chief of staff?
presentation. Oh, no. Somebody will have to go fetch it.
They're all in there in the break room.
Patiently sitting all
Eating the
morning.
donuts. And what was that? Pumpkin spice cake or something?
That was good.
Mr. Maestas?
Maybe they all
Okay.
died. Boarded to death.
But on these recommendations, can we just maybe not discuss them, but agree like what to strike? Because I think you made some really valid points on some of the things I suggested. I think you're totally right. So maybe if we can just avoid getting into like.
Can we discuss this off the bench? Maybe? We're in session right now, and I don't see why you couldn't talk about it, but on the other hand, we gotta stay focused. So, let's see. Good afternoon. I was gonna say good morning, but it's flown by and it's the afternoon. Welcome back, Mr. Probst, Chief of Staff. So I'm eager to get to your item. I think it's an important work for us to address. So please proceed with your presentation.
Thank you, Madam Chair and the members of the commission. I think Patrick is going to pull up what is the latest version of the possible 2023 legislative recommendations, and that is the version that includes recent comments or additions and comments by Commissioner Fishman. So there it is, Madam Chair, members of the commission. As I noted, we sort of bolded some of the items where we felt there was pretty much general consensus amongst the commission in support of those items. But there are a few that I think still need to be resolved as to whether or not you would like to have them as part of your legislative priority list for 2023. And then I think the other part of this discussion that needs to be concluded is any type of prioritization that the commission may have for these items. And staff has reviewed this several times. We don't have anything else to add. We've did take off a couple of items that were pretty clear there wasn't going to be consensus on. For example, the transfer of the transportation division out of the PRC. I know there's some commissioners may support that, others don't. So we did try to take out a couple where we knew there wasn't likely to be consensus. But at this point, I think it's up to the commission to kind of slog through this one last time, if you can, and provide us direction so that we can get this to the legislature in a timely manner for it to be considered as they fit to into the next session.
So just a quick question to move this along. If I
Yes,
may.
Commissioner Fishman.
Do we have any controversy on any of the bolded items? Thank you, Wayne, for bolding some of those items. It's very helpful. That those are things that we do still support. And that would include what was on our 2020 list, which we may want to scroll down to whoever's.
What's your question? What are you asking? Do you want to talk about?
So there are items that Wayne bolded.
Yes.
He feels all the commissioners are on board with. And I'm just quickly asking, is that indeed the case? And do we need to discuss those items any further?
Okay, the first Baldwin one I see is increase the cap on state rural universal service fund with 40 million.
Yes.
I think we do agree on that, but I don't know if it's our top priority. So you just want to.
Well, just see if there's any controversy, if they stay on the list.
I mean, it's in our our SRUSF report to the legislature. We've made that recommendation, but I thought for emphasis, should it be a standalone item on our legislative agenda? Because the legislature gets reports. Do they really extract kind of the key recommendations? So
I used to read.
you were there, sir.
I used to read every word of it.
You know,
Cheap.
I have to say, I'm looking at.
Glad I have tall boots.
We have a case right now that actually relates to this issue insofar as it's going to, it relates to, I guess, the fact that there's already legislation that permits more companies to become owners of the last mile and therefore entitled to access reduction payments. So we're determining which companies can enjoy that benefit. And then that means that even more of the fund will be devoted to those last mile payments to the owners of the last mile. So that means this fund is going to shrink. And if we, I mean, I guess, yes, we've asked to increase that fund to $40 million, but I'm not convinced it will redound to the benefit of the people who need broadband. I think I don't know how much of it will go to pay more access reduction payments, but that's what's happening to this fund. It's getting eaten up by access reduction payments to owners of the last mile, rather than, I mean, if it continues in that vein, I guess there will be a limit at some point for how many access reduction payment recipients there will be. But so I'm not opposing this, but I'm just mentioning that as a way of helping us think about prioritizing.
That was your recommendation, Madam Chair.
I know it was. So I'm not.
And I thought that we discussed that the lion's share of the cap would actually go to broadband. And I think that was the motivation for us recommending that the cap be.
That was then, this is now.
So, but in answer to your question, Commissioner, I don't have any problems with what's in bold. So I'm fine with whatever's in bold.
Other commissioners have any, because I think just in general reading down.
Yeah, let's.
Oh, yeah.
I'm fine with them all too.
Okay, fine. Yes, so thank you for Commissioner Fishman for saving us the time there. I thought you wanted to go through each one, but if we don't have to, that's.
No, unless there's something there that's changed in anybody's minds.
And whoever's scrolling, if you can scroll back up to Commissioner Fishman's comments.
Those are just off the cuff, but.
So the incentive programs for battery storage, I mean, that's already in the Inflation Reduction Act. Do we have state funding? But I was referring to utility scale. That's what I was referring to.
Personally, I'd say no,
Which one
because.
I'm sorry, excuse me, which one is that?
It's
Are you looking on the left side? there?
oh, I'm sorry. Maybe I should start up higher on the loopholes to the ETA. I mean, really, I think all of those are kind of moot because, as you said, Commissioner, I mean, there's already active cases, and I think the Constitution, right, forbids. You guys have been there already.
Yeah.
Right.
So no state
Well, it's
laws
still
can.
under discussion. It's, you know, it's law, so who knows what it really means, but.
But what I'm thinking is that there could be an ETA version 2 that could address other fossil fuel based generation resources that could be abandoned, but I mean, I don't want to be speculative, and I know it's still taboo to revisit the ETA. The only thing I really felt strongly about was if we could, after the fact, at least ask for an economic impact mitigation study to truly quantify the impacts from coal plant closure. But again, I think, you know, the goose is cooked in the two coal plants that the act was written for. So, I mean, I'm willing just to completely just delete
Strike that out.
all of those loopholes in the ETA. If there's any objections to that, I think Commissioner Fishman makes a good. Okay, so then.
Strike that off our list.
Yes.
Fine,
So
I agree.
everything under closing loopholes in the ETA is stricken. So now
we
we're
get a
under
sigh of
gridlock.
relief from Mark over there.
Did we talk about this the statute emulating Colorado law? Did we mention
I think it's later on, but do you guys want to maybe just decide on grid mod, those recommendations?
that? I don't think we need an incentive program. Oh, distributed. Yeah. Well, no. And then IRP.
Oh, so I was going to comment on incentive programs for utilities on the batteries.
Yeah.
Well, you all know that I think utilities over earn already. And we keep giving incentives to do stuff that they should be doing as a matter of course. So, you know, my tendency is to say no to creating incentives
I agree.
for these kinds of things.
Thank you, Commissioner Fishman.
That's just my personal point of view.
Okay, how about item number 2, folks? Amend the IRP law. What for? We just did a rule. I would like to ask, what was in your thought? Might want to explicitly define transmission district. Well, okay, we have included them, but
We have.
probably defined them. But don't want to give utilities an opportunity explicitly. Well, okay, we could. You mean you want to amend it in order to put definitions in there for those?
Yeah,
items?
that was a recommendation by those task forces that were formed after the Grid Mod Act was passed.
I don't think it may be that they wrote that before they saw our final IRP.
They definitely did.
Yeah,
And we're requiring transmission planning.
yeah,
Yeah,
it's
so-
in the rule, so I don't think, unless it's challenged.
Okay, so we can strike 1 and 2.
Yeah. That's really
I guess 3 was already struck.
It's not, I don't see 3, yeah, 4, whatever. I don't think we have a 3. So I don't know, I don't know that this is necessary at all. I think it's quite well captured in the IRP rule,
Okay.
law statute.
Let's strike that too.
Yeah.
All
Okay,
right,
so we're
so
down
let's skip
to-
over the bold stuff.
I think, I thought this next one was too vague. Address mutual domestic water system issues. What do we want them to do? We have to give some specifics, I would think. I definitely think it's a problem that the systems are not getting as much help as they need.
Yeah.
But I don't,
Well, they're not being held accountable, but they're also not getting any support, which we
Right.
discussed. And
right.
boy, we'd sure like to see that. We just haven't put it into a proposal. I don't know, and in a lot of ways, I always look to Teresa, to Jeff for guidance on rural issues, because you're much closer to them than I am.
Well, I think we
Yeah.
all have to think, we all look at these cases and we all know what the problems are.
I know, but just my way of politely asking and showing respect for what input they have.
And the frustration is, Madam Chair, is like, we have like a shared responsibility with NMED, with the Environment Department, and it's like, they're not taking any action with respect to
I
RJV.
can update you on that too. We reached out to them and had one.
You want to use your mic there?
Oh, sorry. Yes, we reached out to them and had one meeting with them. And then Russell and their attorney were gonna meet, and I think they did, but then I think subsequent meetings did not. They were playing phone tag about scheduling, and then the deputy secretary that I had first met with is no longer there. So Russell is in the process of identifying the right person to talk to. So we're in the process of trying to work with them, but their concern was, actually, and specifically in Rosa Joint Ventures, there was a water contamination issue as well, and they felt equally frustrated as we did about their inability to get anything to change there. So I think they're very interested. I know they're very interested in trying to work together with us to come up with proposals to suggest as to how to go forward. And if you have any suggestions, let's list them, and I'll take them over there and talk to this lady. And you're welcome to come, I don't know. It's not the lady now. So we're trying to identify. We're in the process of identifying the right person to talk to. So, but we're working on that. So.
So based on your meetings, do you have anything more specific than that? Because I agree, it's much too vague.
Well,
No, I don't. I think that's our problem right
Throw
now.
out a
We don't
suggestion.
have ideas.
If we don't have it, one thing we can do is request a legislative study of how to support mutual domestic water systems. And maybe that's all we're ready to do. Commissioner Bird's making faces, so I want to know what he's really thinking.
So, I mean, You keep saying support and I assume you mean monetary.
No, actually more management support's what's in my head, but it could be monetary, whatever makes sense.
Oh, I forgot to mention, we also, sorry to interrupt, but we also copied Senator Heinrich's office, and he wrote back saying there is, there's a great possibility for getting, well, I forget how he phrased it, but he said there's a possibility of getting infrastructure money too. So they're very interested in helping as well. So that's why it's really kind of important for us to come up with ideas. And I don't know how fast a legislative report would come, but I think we want to get ideas lined up before we leave. And I'm scheduling a meeting with the senator's office to try to get in and discuss it with them. But we need to, if we're gonna do something like this, we need to, regardless whether we go to the legislature or we go to our Senate, our congressional delegation, we need to firm up some ideas.
Well, so Commissioner Byrd, you'd started. I was wondering if you.
So, getting funds to do projects really isn't that hard. As a mutual domestic, you can get a grant pretty easily. One of the biggest obstacles for it, I'm familiar with two because my mom's in one, I'm in one. And the argument always is, well, if we get a grant, we have to raise our rates. We don't have a choice. And sometimes we don't need to raise the rate. It's because there's money there that's being turned back already every year. It's co-op, right? At the end of the year, you turn the money back. So rather than giving more money back, you would use that to pay off your loan. I say grant, but there's low interest loans, I guess, available for this. And we won't take the loan because we don't want to have to raise our rates. We'll just patch it up. But the law requires that if you do the loan, you have to increase the rates. That doesn't always make financial sense. And so as management, you're thinking that's stupid. We'll just Band-Aid this along until we can get the money gathered up and fix it. As far as help with management, I agree that there should be more oversight or more authority from somewhere that can force mutual domestics to, as we're having this problem with Rosa Joint Ventures and San Brito, because we can only control half the argument. We don't have really control of, when you're in a dogfight, you can't stop the other one from biting you. You got to keep biting back. So there needs to be somebody. If it's not the PRC, somebody needs to have some authority to step in, and maybe it's the AG's office and they don't know it. Just saying. But wherever that authority lies, somebody needs to have authority over them to say you have to follow the rules, because that is a problem we have, is they don't follow the rules.
Well, which rules are there that they're not following?
Well, I have particular ones that I'm
Well,
He doesn't want to out his system.
We're a family. We're fighting each other, not you guys.
So, Madam Chair, Commissioner, I'm just sort of trying to figure out where the commission is on this, because it says, and I think from Commissioner Byrd's comments that he recognizes that mutual domestics are not subject to the jurisdiction of the commission. It's small water systems that are really the problem. So I thought that this was a typo on here, that when we're saying mutual domestics, because it's water, the problem that we're dealing with is the small water systems that are underfunded. They don't have a bond, or anything.
But this says mutual domestics.
where's this?
They,
Oh, yes.
yeah.
it is. What am I?
I can speak to that issue right there.
yeah, I know Commissioner Byrd has issues with his mutual domestic.
I didn't even think about that.
We really only have the mutual domestic involved in this. This is a non-functional mutual domestic that's trying to take over the water system and Rosa Joint Ventures. But
Well, why don't we scratch that, because this is a developing issue and we may have to, maybe deal with it after
It's
the
another
agenda.
It's not really.
After the legislative agenda is finalized, this is just going to have to lag because there's still some developments.
We could leave it open for Commissioner Hall if you like. If you think we can leave it open for you to develop a more specific proposal. But this,
Okay.
as it is, gets crossed off the list.
that's fine. Let's cross this off. the
And if
list.
you have a better idea coming next week or whenever,
Yeah. Well,
Sounds good.
present it to us.
we can put some energy into that now.
Sounds good.
That's great.
Perhaps, Madam Chair, if you develop that, the commission could consider sending a separate letter on this specific issue to the Water and Natural Resources Committee and ask them during the interim of next year to consider the issues that you would raise for them.
Yes, good idea. Okay. All right, fine. So let's see. The next item is supply chain resource adequacy. Look at ways to institutionalize energy security efforts with State Energy Office and PRC working together. And a subcategory here is possibly formalize a centralized listing of critical infrastructure supplies and using executive branch or PRC as a centralized clearinghouse communicator between IOUs, co-ops, others. Comments on this, commissioners? I personally think it's kind of ambitious for the PRC to take on clearinghouse functions like that. And I sort of cringed a little about creating a central list of critical infrastructure supplies on our servers, because it kind of puts a target on our servers if somebody wants to find the critical infrastructure supplies. So, I think it's something that should be done. I'm not sure if we're the ones who should be doing it.
Who had the proposal on this?
Not mine. Is it yours, Commissioner?
I don't think so.
Wayne, do you recall where this came from?
Madam Chair, I'm sorry, I don't.
Okay.
It feels more like it happens at the regulatory level than at the legislative level. What we need to deal with here.
What's that? And what do you mean? It what happens at the regulatory level? Creation of lists?
The institutionalized energy security efforts. It just feels like that should be happening at the regulatory level. It's not a legislative issue right now. So anyway, I don't think we should have it on the list.
I don't either. Let's strike that part off. Okay, next one is transmission costs.
And the previous, excuse me, Madam Chair, we
Sure.
skipped over two of them prior to supply chain.
Oh,
Um,
well, okay, fine.
start addressing rural co-op exemptions. That's kind of vague,
It is vague. So what does that mean?
so we can strike that. And then the recommendation to transfer the Transportation Division to DPS. I'm surprised it's on the list. It certainly didn't come from me, but I know some attempts have been made.
Madam Chair, I think we took that off.
Oh, did we? Okay.
Yeah, I'm not seeing that. Yeah,
Okay, I'm looking at an old list here.
That's one of
I
the ones that
apologize.
eliminated because we know there's not a consensus.
Plus, I think the DOT, when the attempt was made, was saying, we don't know where to put it. Doesn't seem like a good fit. That was my recollection when,
Your recollection
Yeah.
is correct.
Mhm.
okay, sorry about that. I'm looking at an outdated list. I'll just,
look at the screen, yeah, I
Yep.
think.
Madam Chair, we're now on transmission cost description, clarification about what counts as transmission costs.
About what counts as transmission costs. See MJP comments below. What's that? Who's MJP?
Mary Jane Parks.
Okay, transmission. So which ones are hers?
I believe, Madam Chair, that if I remember correctly, page, the next page, related to the community solar, because I know that was that particular
Oh.
suggestion did come from
I see
Mary
something
Jane.
to the effect of a solar bill credit based on avoided cost. Much like recently passed California bill. The problem with using avoided cost in the calculation, however, is that this implies there is a storage component involved, which we don't have in New Mexico. So I don't know, this doesn't look developed yet. So I don't know at this point what we would say.
If
Yeah, I
there's no
don't,
consensus, then let's
Let's drop that.
strike it.
Yeah, okay. So the next one is adding specificity to IRP and PPA standards. That's too vague. We need to know what we're talking about. So I would strike that. I mean, it's something, this is like a good to-do list, maybe for the next commission, but
Yeah.
we don't have a piece of legislation here. So if you don't mind, I'll strike that. Fund low-income energy efficiency repairs for homes that don't now qualify. So it's like a waiver from having to qualify for energy efficiency upgrades because of code failures. That's specific.
This is mine, Madam Chair.
Yeah,
I'm not gonna do a thesis or anything, but I think I brought this up before. The state of Michigan has an energy efficiency and weatherization program,
mhm.
and it's very well funded, but they also have a set aside within the program that if they encounter a home that has code violations that would preclude energy efficiency or weatherization, they actually fix these code violations.
That's nice.
And here in New Mexico, if we go to a house and we encounter a code violation, we just say, bye-bye, you're not eligible.
Mhm.
Thumbs up from me.
What's that?
I'm saying I support this.
I do too. I do too. It's worthless to help low income people if you say they have to pay to get up the code.
Given our state's old housing stock, I mean,
Yeah.
I would imagine the need is great.
Well, and it kind of burns me that we end up spending LIHEAP funds for all this energy waste that's going on.
Exactly.
And in this case, we're actually solving the problem rather than,
So let's keep that on the list.
well, how do we have all 5 commissioners on board
Yes.
with that?
Commissioner Vicente Aguilar, do you support that one? This is the one, it says. Fund low-income energy efficiency repairs for homes that don't now qualify because they have code failure.
And this could apply to the offices of Commissioner Byrd's Mutual Domestic. He doesn't want to tell us about the code violations, but
No, wait a minute, this has to do for homes, but whatever.
could be
It
small
has Nothing
businesses.
to do with their water consumption, so it's okay.
I would
But
just say maybe the adjective energy efficiency repairs is incorrect. It should be
It says upgrade.
code, code correction repairs.
Well, what are you
So
saying?
leave it on there, but let's expand the definition.
Are we not talking about energy efficiency upgrades in this thing?
Yeah.
What? Oh, what are you saying?
Well,
Oh, I didn't see where you were talking about. So you're talking about just saying fund low income repairs for homes that don't now qualify for energy efficiency upgrades.
There's a lot of them don't have like the amperage service they need to have by today's standards.
in fact, what I do is I take energy efficiency out, just like fund low income repairs
Exactly.
for homes that don't now qualify for energy efficiency upgrades because of code failures.
Meter cans are too old.
Yep.
Fine,
Fuse boxes are too old.
okay.
I have some sort of screw-in fuses.
Mhm.
Tenants are too old.
Commissioner Vicente Aguilar, do you have an opinion? Do you have an opinion on this one? Oh, it's got something to show us.
I think we're good.
Or did she?
I think she's good.
So Madam Chair, I think that's the last one that's not bolded.
All right, okay, fine. Hey, we did.
Well done, Commission. We went through that
Very
quick.
efficient.
Yeah.
Okay, well, let's see, then let's start going through the bold ones. We did the
We
increase.
did the bold ones.
Oh, we did
accept-
all of them, clarification and broadband funding.
The only question,
Wait, we didn't look below this. I don't think we covered these. We did the two bolded ones above. But there are more, aren't there? Or do I have an old list? I have a bullet now that says clarification of broadband planning / aligning with SRUSF grants. Is that on the list still? I see it on the screen.
that one is bolded.
Clarification of broadband planning aligning with, I don't see, what do we want them to pass?
I think that's more of a temporal issue because, as you know, as a commission, we went ahead and approved our broadband applications in the absence of a broadband plan. And the Connect New Mexico Council still wanted to review our applications in the absence of a broadband plan. So I think that's just a temporary issue. I think once we have a broadband plan, then all the future awards for broadband projects from the Universal Service Fund will have to be approved by the Connect New Mexico Council for consistency with the statewide broadband plan. So I think that's a temporary situation. I think we can delete that.
All right.
And also, Madam Chair, I think perhaps, and I think this was a suggestion from Commissioner Maestas, if the legislature was to include a representative from the PRC on that council, that might be helpful as well to make sure that.
Isn't that a bullet somewhere?
No, that's one of the, yeah, it was,
It's earlier.
yeah, earlier.
Did we?
I would agree that one could probably.
Yeah.
Oh, yeah.
That's a simple
Oh,
fix.
yeah, we didn't do this one. Did we? Oh, yeah. What did we decide about increased cap on state rural universal service fund? Did we strike that?
Yeah, I think we
I
already,
think
we kind
to
of double
40
covered
million?
it.
Well, I don't care. I think whatever you guys want to do. Do you want to do it or not?
I'm sorry.
I don't want to go back.
If we struck it, we struck it. Okay. Right. So but I do agree that it would be very good to have a representative from the PRC on the Connect New Mexico Council. So let's, everybody okay with that one? Okay.
So we'll strike the cap.
Yes,
Increase
strike the increasing the cap. All right, so we're back down to more funding for mutual domestic water, along with bifurcation of funding and processes for capital funding of projects.
Yeah, I think we just
Same. term.
discussed that, yeah.
So instead of mutual domestic, it's small waters.
Right,
Yeah, I think we should just strike that.
Yeah.
okay, I agree. It's not really refined enough. Funding independent ratepayer advocate, either within the PRC or as an independent organization / individual within another agency or the executive branch to serve as advocate / ombudsman specifically for ratepayer issues.
You can see I had no opinion on this one.
Is it your comments here completely support? Another route would be to redefine this as staff's role. That's true. Currently, they represent the public interest. Seems redundant since I totally agree. Hearing examiners and the commissioners already serve that function. I completely agree with your comments.
We'll strike it.
No,
And I know Michael, no, keep this. This is
I think
great.
it's independent ratepayer advocate. I think that's the qualifier, right? I mean,
exactly. And so staff would be recast.
Well, I'm just saying that's
Or
something that
some
people
other
should
group.
think about. But, staff could become the independent ratepayer advocate is kind of what I'm driving at. there.
Well, we need specificity if we're going to propose
That's
the
true.
law.
That's the issue.
What's the issue?
You would lose the services of staff. Right now, staff's role outside of adjudicating cases, even though it's a fuzzy distinction, because it's to be service staffs of the commission.
Well,
The idea would be to have a separate, instead of the attorney general who's sort of tasked with the role of representing residential ratepayers and small business ratepayers to have, but who has discretion to not participate in cases, have a separate advocate whose statutory duty is to be in every case at the PRC.
Microphone. Sheesh.
I've been scolded for feeding back, so. But the idea would be to have somebody who represents the ratepayer interest in every case. Like right now, we have the Rosa joint ventures, all these small water
Right.
cases. And there's no advocate from outside the agency on behalf of those residential customers.
Correct. That's right. So, well, if you, I would support this idea. I do support this idea.
For me, this is top of the list, but that's just.
So what do you propose though for purposes? I mean, your comments say another route would be.
Oh,
So
that's,
what do you want to do?
no, that was just food for thought, but I think the core idea is in bold, in black, and we don't need to change it.
Okay, fine. So that's a good one. Okay.
And I just want to clarify, it doesn't mean that the attorney general wouldn't necessarily be able to participate. It's just having somebody who would be actually
Dedicated.
right.
I think the more minds that can be applied to ratepayer interest, the better. You know, I mean, I think it should not exclude the
I
AG.
do have a thought on whether this should be within the agency or outside the agency.
I think for true independence, it would be outside the agency.
I might disagree with that, but.
Just
didn't hear what
another
Mike said.
power hungry bureaucrat.
What did you say again?
I said to
Yeah, personally, I'm agnostic on that.
Okay.
I'd like to hear what Mike said again. I didn't hear him.
I was just saying that if it was for true independence, it would be outside the agency.
Yeah. I agree. Okay, so we're going to the policy recommendations now. Number
This
one.
is from 2020. This is what we did previously.
Oh. So, no one's vetted this, none of us have sought through it, let's just read it. Restore PRC stranded cost determination and allocation authority for ETA-driven plant retirements. Strike section 31C from the Energy Transition Act. Let's see, who, does anybody have that language handy?
So Wayne, is it just verboten to even mention changing the ETA in any way still? Is it just hissing into the wind, so to speak?
I mean,
I think,
I mean, that's what Joe was saying.
yeah, I think the ship has sailed.
yeah.
So
it did.
would that be a reason to strike this?
Okay,
Chair, I think it's possible at some point the ETA,
Yeah.
like all those may be revisited, but I'm not sensing
You know-
an appetite right now.
So,
I looked up that language. There's one clause, instead of taking the whole section out, there's just a clause at the end that could be taken out, but we might be able to devote our resources more wisely. Let's look at the rest. Restore PRC, return on equity adjustment authority for decoupling proposals.
Oh, so what do we do with number one there? Did we just strike it?
Well, tell me what you guys want to do.
I don't want to put Wade in an uncomfortable position when he's looking at legislative reality, and I think we should trust his input.
Yes, that's what I think. So I think we should strike it based on.
I think we should, this attempt was already made and it failed, and there were repercussions. It divided the Democratic Senate caucus. Because that
Yeah,
attempt
so
was
let's-
made, so.
Let's not
That's a
go
good
there.
point. So unfortunately, we're striking it for now, right? All right, number two, restore POC, return on equity adjustment authority for decoupling proposals. So the purpose here would be to restore our authority to determine and adjust for the impact of reduced utility risk inherent with guaranteed revenue. The idea here is that, okay, wait, preserves essential opportunity to balance ratepayer versus investor interests on a case-by-case basis. I think the idea here is that when you have decoupling, there's a sum certain that's identified as a
Mhm.
revenue, and then you true it up later, in a subsequent year.
They get a true up to maintain a
You true up
return
to
and
maintain.
eliminates risk.
And it's more levelized out, but since it is levelized out, it inherently reduces the risk to the utilities. They have more certainty.
Yep.
And so therefore, since their risk is lower, we should be free to adjust their return on equity down a little to reflect their level of risk. And that has been taken away by this provision, which says the PRC cannot adjust the return on equity as a result of changes in utility risk. So they're basically saying they're taking that tool away from us to balance the competing interest to serve the public interest, is the way I see it.
Yeah,
I think this is an extremely important thing. I mean, I guess there are other tools that can be used by hearing examiners, but it depends on the hearing examiner.
I don't think we'd be successful with this, but I do think we just need to keep putting the concept forward. We need fair rates of return, and we shouldn't just be locking things in. So,
Which right now.
I think that was a big victory for Mr. Fenton over there. But,
He did
I
it all.
don't think it's necessarily good policy in terms of regulation.
I don't think it's good policy, but.
So I think we should leave it there personally, but
All right. Any objection to leaving that on the list, folks? No. Okay. Next one is lower capacity thresholds for PRC location control of electric transmission lines and generation plants. Wind and solar installations require much larger footprints to generate energy equivalent to fossil fuel installations. That just seems logical. So we'd have to have, well, wait a minute, thresholds for location control of transmission lines and generation plants. So we have arrays out there that would be whatever size they are, but they might be using lower size electric transmission lines.
I don't know why transmission lines is in there when I'm looking
Because
at
I
it.
think the lines would still have to be pretty big.
Do you want to eliminate transmission lines from that? I'm fine with doing that. Just to
Yes.
clarify,
Let's make it easier. Yeah. I think they're,
less of a hurdle for Wayne to have to pitch.
yeah, okay. Yeah, it makes it easier for him. I think we should refine that. We should examine the question and see what size lines are being used by the arrays out there. I know the big arrays use 345, right? But I don't know how many arrays are small enough to use something smaller, but I think they start out with 345. But
Well, this is for
Take
location
it out.
control.
Right.
So I don't think we need to get into
No,
that here.
you're right. Well, it's fine. Okay. Okay, number 4, provide state support for hiring and training rural ambulance drivers and EMTs where local jurisdictions have difficulty finding them. Okay, what support do we want to do? Money? Training?
Well, they're kind of doing with less, it'd be nice if rural services had the same expertise on their ambulances that urban folks do.
Well, it would be, I think,
So I don't mind
Only
giving them
fair.
subsidy to some rural areas so that their ambulances have professional.
so you're talking money, right? You want to say subsidies, for state support for hiring.
Jeff is struggling with
vague.
that because he's fiscal conservative versus serving his community.
Want the specificity. How do you want to phrase this? But Steve, I'm looking at you.
Oh,
Child number 2.
I assume this is something you put in, right?
pardon?
Did you put this one in? Is this your?
I can't recall, but I think it's a good idea, personally.
I can explain at least the genesis of it was the Angel Fire Eagle Nest situation where Eagle Nest didn't have EMTs and they had to terminate their service, and Angel Fire had to pick up the slack.
Oh, they're not the only.
But they were constrained and they tried billing Eagle Nest for the cost burden associated with covering the Eagle Nest area. And so I think that's an example where you had a lack of rural EMTs and it impacted an adjacent community that did have them, but couldn't accommodate the larger area.
Right. So the question is, will funding solve this problem? I mean, if we get higher salaries for EMTs, will they be attracted to a different district? Or should there be a pool of trained employees? I mean, we need to propose something specific for Wayne to be able to
Jeffrey has a
win votes.
So
Yes.
currently what's happening is people volunteer to be trained as EMTs. They get sent off. It's like $9,000 for training. But it's somebody who lives locally already, because it's a volunteer ambulance service. They're not paid service.
Mhm.
But there's more than just Eagles Nest, Bond, San Home. There's a number of rural communities that there's nobody currently trained. And so it takes like 10 months or something to get the training, $9,000, in fees. The other option, and this was put in, and we've talked about that with Senator Campos, Senator Woods, is that these requirements were proposed and pushed by the unions in the urban areas, because they want to make sure that their guys are getting all the jobs on the EMT, on all the ambulances, and that's wonderful when you're in paid positions.
We're gonna lose the commissioner in 4 minutes. So,
Oh, is he going?
I think he's interested.
So
in this.
anyway. It may be simpler to ease the requirements, because there's still a problem of finding people available to do the.
You and he want to get
volunteer.
together and talk about how to refine that language.
Yeah, we can do that.
Why don't you do that? Okay, let's go on. Pass a memorial to study and reevaluate access reduction support payments to rural ILECs. Well, I don't see a downside. I mean, there's already a statute that's letting new companies become owners of access be recipients of these supports, but I don't know what the appetite would be. Let's go to the next one and go back to that maybe. Provide funding to help customers repay utility account debt accumulated because of the governor's pandemic and emergency orders. Where is that yours, Joe? And what do you have to say if it is?
I don't recall, but I think that was way before the emergency rental assistance program. So we have that. They're still dispersing money.
So we can strike
Yes,
this.
I think that's stale. That's probably outdated.
Okay. Let's then the last three, fund up PRC operating budget with utility fees to be included in utility recoverable operating expenses. I'm for that.
Definitely.
Seems so logical. I think it might be easier to get people to vote for it. Expand available resource. Are we all okay on that one?
Yes.
Teresa, you too, Commissioner Vicente Aguilar?
Teresa?
Okay. Expand available sources of education credits for commissioners to include providers of utility law and utility accounting courses, CEUs. Allow for broader commissioner education and training options. Avoids repeating the same courses year after year. I think that is very valuable because there are many other places where you can get very good training, continuing training. I'm supportive of that one.
I would include assistance as well.
Yes. I agree. Okay. And assistance. Okay. Provide funding. Number 3, provide funding for a permanent PRC office that is sufficient to house authorized FTE. Let's let the next commissioner do that. We aren't going to be around long enough for that.
Wayne, any thoughts on those concerns that you have?
Madam Chair, members of the commissioners, all three of those would probably be, from my perspective, priorities. I think all of them, number one would be my number one priority. Number 3 is still a priority in my opinion.
And Madam Chair, I think we really need to go to bat on that first one because it is such a huge precedent, but it's not unlike most of the other commissions. I think we're one of the few that's not allowed to retain our fees. Now they're loosening their grip by letting us retain community solar program fees. But again, we've really got to work hard at that.
Can we ask? I agree with you. And Steve, I see you want to say something.
Well, I was just going to say, to me, that if we got down to brass tacks and the top 2 priorities, the top 2 would be this one and the independent consumer advocates office.
You're talking about the operating budget, get our operating budget funded by
Exactly.
fees.
Those
And-
2 to me are the 2 top.
What about, I had put stars down next to other ones. That must have been
Madam
my
Chair, before you
first.
guys go on, I've got to go. But I must say, it's really nice to see all my colleagues here in the same room. And Wayne, thank you for gathering us this morning. It was just great to see so much staff, in person. Anyway, great job in doing that.
Thank you, Madam Chair. Before you go, Commissioner, because I was going to cover this during my communication with the chief of staff, but it meant a lot to staff that you were here today. It did. I promise you, but it meant a lot to see all of you here. So,
Well,
thank you.
and just to reiterate, it meant a lot to us that you asked, that you put it together. Thank you.
Madam Chair,
Yes.
can I go also?
Okay.
I want to thank Wayne and the entire staff. I sent an email, thank you for the morning brunch, but I saw a lot of happy faces, maybe coming back from the pandemic, but just what Vice Chairman Yentman said, it's just so nice to come together. And Commissioner Byrd shared the same idea as well. It's really nice, and it's a beautiful day, and we all picked a good day to bring us all together.
Thank you, Commissioner Vicente Aguilar.
Madam Chair,
Yes, who's that?
this is Hans Muller with OGC. Before I lose a quorum,
Yes.
I need to make the commission aware I have an emergency matter that needs immediate attention, so I will need a quorum to stay in the hearing room. It's a reissuance of an ambulance certificate, so it does need to get heard today. I'll be bringing it before the commission as an emergency matter. So
Okay.
at least 3 commissioners, please stand by.
Okay, we will. How
Will
soon
do.
do you want to present it? You can present it right now, Hans, if you'd like.
Madam Chair, I think I have enough on the legislative priorities to at least get you a draft letter that, you can see, go through one more time.
Okay, wonderful. Thank you very much.
Thank you.
Thank you very much. Yeah, and thanks for. Thanks. Yeah. All right, Hans, do you want to present now, please?
Sure. Thank you, Madam Chair. This matter was just brought to my attention by transportation staff during the course less than an hour ago. This is in the matter of the application of City of Roswell for reissuance of their certificate number 26770 to provide ambulance service. It is case 22-289 TRM. This will be an order granting them temporary authority to provide ambulance service. I was just notified that their certificate is due to expire tomorrow, November 19th. And that transportation staff is requesting temporary authority to provide ambulance service pending the final review and recommendation of that application. Essentially, this would be, it's my understanding that this would be posted on our website today. So we would be in a 20-day period of notice prior to making that final recommendation. But seeing as how this is the ambulance service and that their certificate would ordinarily expire tomorrow, recommending providing them with temporary authority so that they continue providing ambulance service over the course of the holidays for the next 20 days. So with that, I'll stand for any questions. And I believe Mike wanted me to mention that seeing how, as this is in the matter of public safety, this falls under an Open Meeting Act exception, as this was not previously published on the agenda, but this was brought to my attention this afternoon by transportation staff. So my prepared order would grant them temporary authority under their current certificate number 26770 until the matter is until the final recommendation is proposed to the commission.
Well, until the commission makes a decision on it, then. I mean, you might propose.
Correct. We'll go through the normal standards of that staff would review the application for reissuance, make a recommended decision, and of course, that recommendation would then be approved by the commission at the last meeting right now.
Okay, so you want us to time it for the last meeting then? Is that how you would word it? So it'll approve their authority until a decision is rendered by the commission on a certain date. You want to do it that way?
I don't believe a certain date is necessary.
Okay.
We will have this on an agenda before December 16th. So
I would think
just
so.
until approval by the commission is fine for purposes.
Okay, fine. Commissioners, is anybody opposed to this?
I move to approve
Okay,
the order.
got a second?
Second.
Okay, we have a motion and a second. Can you take a roll call, Mike, please?
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Cynthia Aguilar,
Aye.
and Commissioner Bishop.
Aye.
Was 4-0.
Okay,
Hans.
thank
Thank
you.
you.
And Hans, please proceed with an order. And you, it'll be something. Yeah, it's already.
And
Please
Madam
take
Chair,
care of it.
Commissioner, I just communicate to Hans, we need to prepare a letter compliant with the Open Meeting Act, advising the Attorney General of the emergency action, basis for the action, and that this was, technically would otherwise be an Open Meeting Act violation.
Correct. I will draft that up, Mike. Thank you.
Thanks.
Thank you, Hans. Okay, let's see, now we have to go to communications with chief of staff. None. Okay, communications with general counsel.
I think that was probably it.
Okay, thank you.
Well, Madam Chair, one quick reminder.
Yes,
Next week's open meeting is canceled. With the holiday, I will put out a notice of cancellation to be posted this afternoon. And I would just like to remind the commission that the remaining meetings due to the closure of the Bochum building will be via Zoom, as the Bochum building will be closed. So the last three meetings of the year will all be Zoom format only.
oh my gosh, this is the last time.
And then we were just getting reacquainted.
Just having. I'm really disappointed now.
And the agenda for the November 30th meeting, which will be the next open meeting, will be issued Wednesday by noon next week due to the I believe the administrative leave in the afternoon. So we'll be kind of on a tight schedule to get that agenda up and posted. It looks to be the early peek at it, looks to be a very packed agenda. I'll affectionately refer to it as the agenda for November 30th and December 1st right now. But I just wanted to advise the commissioners that that agenda will be posted Wednesday, and materials will be distributed to the commission as soon as we are able to provide them.
Okay, thank you, Hans. I appreciate that. Okay, so that's it for the general counsel communications, I take it at this point. Communications with commissioners.
Madam Chair.
Yes,
Go ahead. No,
he said,
I wanted to quit on vacation, but apparently.
No, forget it. So back in May, Logan Longhorns won the state championship, and it was made in jest, but somebody asked if they could get a ball signed by the championship team. And so I've already given one to Commissioner Cynthia Aguilar and Commissioner Maestas,
Hey,
but I wanted to present my colleagues, each with a ball of the championship team, signed by the championship team, Logan High School 2022.
oh, this is a wonderful.
thank you. And congratulations.
Thanks for so much. I will never forget you, Commissioner Byrd. I won't. I'll keep this close to me. Thank you so much.
You're welcome.
It's
You brought family values back to my
you.
corroded urban soul.
I
Thank
think that's
you.
The heart was 3 sizes too small.
Yeah,
So you're welcome, guys.
Anybody
I thought
else
that
have
was a
any,
good
have
suggestion.
any communications? I do. I have a couple of things, I'm sorry. One is that, let's see, I think presently we're scheduled to have our last open meeting on December 14th. Wait, I see, oh, this is just perpetual. I think that's what we're scheduled to do. Is that correct? You know, I wanted to ask if the commission was interested, would indulge the idea of having an abbreviated open meeting on the 19th. And I have two issues I wanted to bring before the commission before we left. And one relates to the wildfire management research that the law student was doing for me. And when he presented to us, he had looked at the IOU plans, but hadn't yet looked at rural co-op plans. And, you know, I think rural co-ops are often more vulnerable to wildfire issues and deserve some attention. And, but unfortunately, he's had to attend this conference out of the country. And then when he comes back, he immediately has finals. So he wouldn't be available to present until the end of his final week, which coincides. His last final is on the last day, on the 14th. So I wondered if we could have another session just to listen to that. But then another issue that we're working on is we're issuing bench request questions. We issued them yesterday in the grid modernization rulemaking, and we'll be getting answers back. Let's see, I think it's in the first week of December. And actually, I don't remember. Does it the 5th, December 5th? However, it may be that parties will ask for more time, which we would maybe have to provide because we generated quite a lot of questions. But in any case, I would like to be able to put together some sort of a draft discussion of a proposed NOPR. Certainly, we won't be able to complete the rulemaking at this point. But we have so much institutional knowledge and knowledge in the base of people who've been participating both in grid mod and in interconnection that I think it's important to kind of capture that value of that combined knowledge in their comments and encapsulate it in a form that the next commission will be able to start with, because hopefully they'll carry on the baton and pass the grid modernization rule. But I'd like to be able to put the best piece of work we can forward for them. So that would be the other thing I'd want the commission to look at, and it wouldn't have to, I don't know at this point whether or not we'd have anything that would really be in the form of a full NOPR, but if not, it would be a discussion draft, Judy was telling me could be. And so that would be something we could at least look at. So those were two things I was hoping the commission could lay eyes on before we have our last meeting.
So,
Or in our last meeting, which I would propose maybe the 19th or something. It'd be the next week, not on the, we won't be able to achieve it on the 14th, but if we did it, say Monday, the 19th on Zoom.
Madam Chair,
Yeah.
respectfully disagree with setting up a separate meeting. And I don't think it's a good idea to do a draft NOPR.
Well, I
well,
think
let
it
me-
will be in a draft.
Well, let me finish the thought here. Is I think we have substantial reporting from Arthur that outlines our thinking, and we'll have the responses to the bench requests that we put out, and that will give a pretty good record for the incoming commission to work from in setting up a grid modernization rule. And I think us rushing to put together some well, let me finish my thought. To put together something that we're not going to be ruling on is more likely to seem to the commission like us trying to control something that is basically is going to be their decision to make. And I don't think it's a good direction to go. I don't think it's going to be particularly constructive. And I do think we've presented a lot of good work that they can build on, and that our OGC will be reviewing with them. And so to me, it doesn't feel like productive work.
Oh, well, I don't see it that way.
So
I
I
see
mean,
it-
I obviously, but
Yeah,
I just respectfully disagree.
well, I hear you. I understand. I just think that, you know, as long as we're in the office, we should be doing what we think is productive. And I don't see a downside, because I guess I don't know. I don't really see it as an effort to steer things one way or another. I just think it's an effort to try to bring the information together, and, you know, rather than just have disparate questions and answers, at least organize it for the next commission. So anyhow, those are my thoughts about having just a brief extra meeting on Zoom for that early in the week, like the 19th, because the holiday is, you know, the Christmas Eve is on Saturday. So what's the appetite for that? You guys have any thoughts, or do you want to think about it? I'm just proposing it now because we have some time in between now and then to think about it.
Discuss it later.
What was that?
We can discuss it later.
Okay, sounds good. All right, thank you very much. Okay, we're adjourned.
So just